my lord, may I be permitted to take leave to file one matter and move it on the basis of the tremendous urgency. Urgency is that, my lord, my
Group 8
application.
matters?
My lord,
Group 8 matters?
Group 8 matters.
Okay.
My lord, the urgency is that my FPS dealership application, which has been rejected despite of all necessary qualifications which I have, at the same time, another person's applications, which was based on all false statements, including he made 2 applications and he did not have the necessary qualifications, he has been given the license. Which if the I am apprehending that allotment will be done soon. So you kindly take it up tomorrow at any point of the time.
Today you are filing this?
I am filing this.
You intend to move it tomorrow?
Tomorrow. So if the leave is given, Lordship, tomorrow, day after tomorrow, whenever your Lordship
serve
fixes,
upon them.
I will serve upon them.
Very good. Leave granted. Tomorrow.
Similar prayer, my lord. Similar prayer, my lord. The only change is that, my lord, here the private respondent who has been given the license, he has a criminal antecedent, my lord.
Criminal antecedent may be?
Yes,
that
my
is
lord.
not barred to give license?
No, my lord. The thing is, at the time of inquiry, he has submitted all false documents, my lord. Lord, I am
altogether separate issue, but the criminal incident.
No, my lord. That is where the
Essential Commodities Act, that can be understood.
That is where the falsity is, that, my lord, at the time of inquiry, he has submitted all those false documents, even not highlighting.
Okay, I will take up it.
My lord, if my lord kindly gives me the leave.
Tomorrow.
Not tomorrow, my lord, on Monday. My lord, in the meantime, Monday. My lord. I have to serve to the.
It will appear Monday.
My lord, it will no, my lord. Usually it will appear, but without the leave, my lord, it will may appear in the down of the list, my lord. The only thing is that the private respondent resides in Uttar Dinajpur. That's why I need that time to complete the service.
Dinajpur. So it is a circuit bench matter?
No, not a circuit bench matter. Here.
Okay.
Monday.
I will serve the private respondent by email, Lordship.
You serve the private respondent and the state.
Your Lordship.
Yes.
Item number 139 to 142. New motion matter. Last 4 matters, Your Lordship, of the today's list. All 4 are vacancies matter of under 2024 control order, Your Lordship. Your Lordship has passed so many orders regarding control order 2024, challenging the virus of the age limit. If Your Lordship kindly take it up tomorrow under heading mention matter, because
we take up the matters, other matters.
Your Lordship, last 4 matters, Your Lordship. Only take not more than 2 minutes, Your Lordship.
Item number
139 to 142 of today's list, Your Lordship.
If not taken up today.
As Your Lordship.
Okay, call the list.
I wait for the petitioner. But these 3 matters are, my lord, similar in nature, my lord, where the state has challenged the maintainability, my lord. Although, my lord, this is a 2013 notification, I'm covered by, my lord, Lordship's own judgments, my lord, hundreds of judgments, and the division bench as well, my lord. The only issue is, my lord, item numbers 9 and 10, my lord, I'm enjoying an interim order. Only item number 8, my lord, there is no interim order.
Who is appearing for the state? No one is appearing.
Mr. Shengupta had appeared. Lordship, this is the same matter, my lord, at least this is the 5th time. My lord, Lordship will only protect me, my lord, so whereas, my lord, same order can be passed, my lord, as passed in item numbers 8 and 9. Sorry, 9 and 10. And I had informed them also, my lord, that it had been fixed at 10:30.
Please take down. None appears on behalf of the state respondent. This matter appearing in the list for quite few days for hearing on the point of maintainability raised on behalf of the state authority. It appears that similar two matters being item number 8, 9 and 10 of today's list are also pending for hearing on the point of maintainability. Full stop. It appears that the
Page 3, my lord, paragraph, the first paragraph at page 3.
validity of control order 2013 is under challenge before this court in the instant writ petition. Full stop. Considering the prayer of the petitioner and till the issue of maintainability be decided, this court has directed the state authority to follow the directives of the Honorable Division Bench passed in the batch of appeals in MAT 1543 of 2024 in terms of Division Bench order dated 6th August 2024, most specifically in paragraph 10 and 11 of the said order. Having heard the learned counsel for the petitioner, comma, as learned counsel are not appearing on behalf of the state, I think it necessary to pass the similar order. As like the other matters being serial number 9 and 10 of today's list. Hence, I'm okay. Hence, it is ordered that till the issue of maintainability as raised by the state respondent be decided, comma, the state authority must follow the directives of the Honorable Division Bench passed in batch of appeals being MAT 1543 of 2024 in terms of paragraph 10 and 11 of the said order dated 6th August 2024. Let these matters be go out of the list, particularly what to mention.
Right. Deep look.
It একটা অর্ডার হবে বা না ও দুটো তো অর্ডার করা আছে, ঠিক আছে, ও দুটো শুধু অর্ডার হবে, পরপর লিখুন। Let the matter go out of the list, particularly what to mention. Item number 9 and 10. Thank you. Next.
Right.
For correction of cost attenders, in the ordering portion, the name of the petitioner was recorded as
Order dated?
17th March 25.
Yes. What is the name?
Lordship, the name was recorded as SHRI 3, that will be SRI, and Gautam Kaur GOU, that will be GAU.
GAU,
Yeah,
not GOU.
not GOU. That will be correct, Lordship.
This matter appears for correction. Full stop. In the order dated 17th of March 2025, in the cause title, the name of the petitioner should be mentioned as, should be read as Sri Gautam Kaur, SRI GAU.
SRI GAU TAM.
GAU TAM KAR. instead of এখানে যেটা আছে SHRI GOUTAM কর, দুটো নামই ইনভার্টেড কমার মধ্যে রাখবেন, ডাবল ইনভার্টেড কমার মধ্যে। নেক্সট,
I am for the respondent. তাকে দিয়েছি ইয়ে reply.
On last question, my learned friend was not present. I have submitted before your lordship. The vacancy notification has been notified. I participated in the selection process by disclosing 2 bank accounts. Admittedly, my lord, on the last date of application, prior to that, in so far the single account is concerned, some money has been withdrawn. But so far the joint account is concerned, along with my elder brother, more than money was there. If your lordship, 2 bank accounts I am showing to your lordship. First, your lordship kindly turn to at page first, your lordship kindly turn to my lord page 39. This is in my individual name, middle portion top, Janatul Biplab Tora is the petition before your lordship. Kindly come to the bottom portion of the statement. 6 September 2024. Money was there 55,000. Record is 50. But I have submitted application on 7 September. Admittedly, on that day, some money has been withdrawn due to the serious illness of my father. Your lordship, kindly turn the page. On 7, money was not there. What is the requirement? My father ultimately died. But if you lordship, kindly turn to page 48, the joint bank account. Page 48 is the joint bank account in along with my elder brother. Kindly see. Ujupta, Tanto, Yemen, and petition before your lordship. Page 50, kindly turn up. Top portion middle, Ujufa Ivan Yasmin, who is my elder brother, and Janatul Biplab Tora. My lordship, kindly see from 4th September to 12th September, 3,29,000 and 1,69,000. So more than 50,000. I have categorically made out a case. The subdivisional controller told me that since inquiry has been conducted, subsequently my application has been rejected. The allegation is that since the joint bank account first name is holding by elder brother, this account cannot be taken into note. But they file an opposition, affidavit in opposition, not report. That submission has never been denied. Actually, they have accepted my, admitted my affirmation. So far my writ is concerned. If you lordship kindly turn to 2-3 pages of paragraphs. Page 3, paragraph 4. May I read, my lord?
Yes.
I have made out the petition states that being the most eligible and most suitable candidate and having all eligibility criteria as per vacancy notification so and so, including shop-com go down and financial solvency. On 7th September,
You are reading page 3, paragraph?
page 3, paragraph, my lord, 4.
Paragraph 4 of your read petition?
Read petition. This has not been denied in the opposition.
Yes.
Page 3, paragraph 4, my lord, your petition states that being the most suitable and eligible candidate and having all eligibility criteria as per vacancy notification and so on so, including shop-com go down. On so and so, your petition submitted his duly filled in prescribed application so and so, then kindly come to my lord. Last but one paragraph of page 4. Third paragraph. Your petition states that there are 2 bank accounts of your petitioner. One is in IDFC Bank, First Bank, and another one is the State Bank. It is pertinent to mention that an SBI savings account of your petitioner is a joint account, along with the elder brother of your petitioner, and in terms of the vacancy notification dated so and so, there is no part to hold a joint account by an applicant. Your petitioner further states that although your petitioner maintained the money, then the required money as working capital pursuant to the vacancy notification dated so and so in both the accounts. However, due to medical emergency of your father, your petitioner compelled to withdraw some amount of money from the bank account just before one day of the date of submission of the application, prescribed application, on 6 September 2020. But in the joint bank account, your petitioner maintained the money, then the required money, as working capital pursuant to the factory so and so. Then, paragraph 7. The petitioner states that during course of inquiry, your petitioner submitted all the required documents, including sketch map of shop-com go down and the bank account detail of the both the bank accounts. However, after taking note of both the accounts, details of the inquiring personnel expressed there so and so, they kindly turn the page, my lord. Page 6, paragraph 8. It states that after conducting such inquiry, the inquiring person directed the petitioner to submit both the bank accounts details before the subdivisional controller dome call. Accordingly, your petitioner time and again visited the so-and-so. Then paragraph 9, your petitioner states that when your petitioner was waiting for the personal interview and personal hearing, all on a sudden, with an utter shock and surprise, subdivisional controller dome call verbally informed into your petitioner that the application of your petitioner could not be recommended before the higher authority. Accordingly, your petitioner visited the office of the subdivisional controller prudence supply dome call and came to learn that the subdivisional controller dome call is going to reject the application of your petitioner. Since in the joint bank account of your petitioner, the name of your petitioner has been reflected as second account holder. Well, these are my specific case. There is no denial of the also same also. Ultimately, my application has been rejected. And paragraph 11, I have once again stated, page 7, your petitioner states that without recommending the so-and-so on a threshold considering the petitioner ineligible, I have not been called for in the interview also. On the sole ground, and kindly take up their opposition. No denial. You want to kindly go through the entire. Only submission is that so far the other bank account is concerned. State Bank joint account has never been mentioned anywhere. Paragraph 5, 6, 8, 9, 10, and my statement in the writ petition has not been denied. This is not a report, but it is an affidavit in opposition. You have to kindly see the condition in the vacancy notice. Only bank account. Kindly take note of, my lord. It starts from page 18. If you have to kindly turn to page 19. Part 2, clause 7 from bottom. Working capital of fund required at the time of application. Working capital or fund. Applicants for dealership must have a bank balance of rupees 50,000 only in from the savings account, current account, flexi deposit schedule community bank, and post office as working capital on the date of application. Not only bank account, fixed deposit, everything. There is no whisper that it cannot be a joint account. And even if it is divided, it will comes around more than 1 lakh, 75,000. Kindly once again, kindly take up my State Bank account at page, my lord. Page, my lord, 39. 39 is the IDBI Bank, and the State Bank starts from, my lord, page 48. Kindly turn the page, page 50. On 4th, 3,29,000. On 12th, 1,60,000 has been withdrawn. 1,69,000. So on 7th September, it was 3,29,000. 4 times, near about. From 4th to 11th, it was 3,29,000. 12th, 1,60,000 withdrawn. It becomes 1,69,000. This is the only reason for rejection of my application.
Yes.
I have handed over, your lordship, the uploaded copy on the last occasion, which reflects that my application has been rejected. After filing the writ petition, that has been uploaded, and I have handed over to your lordship. I'm grateful.
Yes, my lord, your lordship, kindly take my report in the form of affidavit. Kindly see page 6. My lord, this is the notification relevant, page 7. Your lordship, you will find, my lord, this notification also in the writ petition. My lord, my learned senior friend has placed Roman 7 of page 7, Roman 7A. Applicants for dealership must have a bank balance of rupees 50,000 only in the form of savings account, current or fixed, flexi deposit in a scheduled commercial bank and or post office as working capital on the date of application. Now, your lordship, kindly consider page 10 is the letter, my lord, issued by the subdivisional controller that they will, my lord, cause an inquiry. Then page, I'm sorry, ma'am.
Yes.
Page 10, my lord, is the letter dated 3rd December 2024, my lord, issued by the subdivisional controller, food and supplies, my lord, that they will, my lord, conduct an inquiry. Then page 11 is the relevant document, my lord. This is the inquiry report.
Yes.
My lord, kindly see hand side top. Date of inquiry 20th December 2024.
Yes.
Then my lord, left hand side box, serial number 5, last date for application 7 September 2024. Date of this application 7 September 2024. Now, this 50,000 is required to be, my lord, deposited on the date of application that your lordship will find on page 7. So, as on 7 September 2024, my lord, one must show that he has, my lord, 50,000 in his account. Now, your lordship, kindly consider page 12, serial number 23.
Yes.
Whether the applicant is financially solvent as per vacancy notice, please mention the details of the account statement, deposit certificate, FD, TD, etc. Rupees 3899, 3,899 as on 7 September 2024 under account such and such, branch Salt Lake. So admittedly, my lord, this is also an admitted position that on the date of application, my lord, the amount was 3,899. Now kindly consider, my lord, page 16. This is part of the last page of the inquiry report, my lord.
Yes.
My lord, serial number 78. Overall comments with positive or negative recommendation. The applicant was not financially solvent at the time of application, that is 7 September 2024 as per order number such and such. Now this was the finding. Now this, my lord, your lordship will corroborate from page 20. Page 20 is the bank statement of the petitioner, my lord. Kindly see left hand side 1, 2, 3, fourth column. The date your lordship will find transaction date 7 September 2024. Fourth column of page 20, my lord. And corresponding box at right hand side your lordship will find 3899. So on the date of the application, my lord, the amount was 3899. Now the question is, my lord, these are the documents which are uploaded by the applicant. We consider this in accordance with law. My lord, there are other candidates, my lord, whose applications were rejected for failing, my lord, or my lord, for not adhering to the, my lord, conditions laid down in the notification. Therefore, my lord, the question is, my lord, whether there is any procedural infirmity on the part of the respondents or not. There is no illegality, there is no procedural infirmity. Now, scope of judicial review, your lordship knows, my lord, unless there is an illegality or procedural infirmity, my lord, your lordship knows the scope is very limited. Now, what documents subsequently, the petitioner, my lord, has handed over, or my lord requested to consider this for on a subsequent date, my lord, is another aspect of the matter. But on the date when these documents were uploaded, and on that date, admittedly, my lord, the amount was 3899, which is much below than 50,000. Well, these are my submissions.
Yes. What is page 17 of your report?
My lord, 17 is the, well, the field report, I will say, my lord. The initial documents were considered, my lord. Your lordship will find, my lord, these are, my lord, the inquiry, member of the inquiry committee, my lord. They filled up this form. This is part of the inquiry report, and your lordship will find right hand side, my lord, this side, my lord. Kindly consider these two columns. My lord, the IDFC account number was quoted, and then As on 7th September 2024, your lordship will find that rupees 3899. So these, my lord, these are the field reports, my lord. Thereafter, my lord, this form was filled up, my lord, accordingly.
Okay. Yes. Reply.
Sir, can you take up your report, sorry, my lord, opposition? How my candidature has been, kindly take note. Page 11, if you lordship, kindly of the evidence. Kindly come to serial number 15. Otherwise, my candidature. OBC, serial number 15, 17 has suddenly passed. Then kindly turn to page 13. This is their report. Serial number 52. Go down. B. Number of components. Area 585,179 square foot. Have you lordship got my lord? Then size of the shop counter 235 square foot. Requirement is 200 and 585 requirement is 400. Then kindly turn the page. Serial number 54. Area has been given. Then height of the godown 10 feet. Pakka, cemented, concrete slab 59, 58, all four walls. Paragraph 61. Now the case which I have made out before lordship, my lord, admittedly my learned friend is correct. I could not upload it along with my application so far the joint account is concerned. My specific statement in my petition on the date of inspection I have handed over. Again, I have given to the subdivisional controller. But what is the eligibility on the date of application? Your lordship knows there are judgments when kindly consider the graduation is requirement. I passed graduate before the last date of submission of application. I could not produce the same. But it tantamount that I was graduate on the date of submission of application. Had I got the result subsequent thereto, it cannot be considered. But it appears on that day bank account money was there. I have categorically stated my petition. They have not denied the same also. That I have handed over these documents, both the accounts, before the inspecting personnel, and subsequently as per their instruction to the subdivisional controller, there is no denial. They accepted the position. So on the date of inspection, along with other candidates, I fulfilled also all eligibility criteria. And it appears on the date of application was money in my bank account. The requirement is that last date of application, I have to show 50,000. Admittedly, even if divided by 2, along with my brother, it comes around my lord 1,79,000. So money was not there. This is not the case of the state also. Money was deposited subsequently. This is not of the case of the state also. State's case is that you have not uploaded it. Admittedly, I have not uploaded. Does it mean I am not eligible candidate? On the date of inspection, when I produced both the bank accounts, you have written in the inquiry report, my godown, shop, qualification, everything satisfied. You are going to issue appointment letter or grant license to an inferior candidate on the ground that I have not uploaded a single document. But this does not, my lord, modify. And if you also kindly see in the application form, I have annexed the advertisement. There is no column to say which money, under which column money should be given. If you also kindly come to advertisement, page 18. There is no provision that I have to disclose the bank account.
Page
It starts from page 18, not a single column.
page 18.
18. Only, my lord, page 19, Roman 7, bank account. Kindly see. There is no whisper that I have to enclose all the documents. In this advertisement, there is no such column. Only I have to keep the money in the bank account. Clause 7, page 19. Working capital or fund required at the time of application. These are the on the date of application that was there. There is no whisper that I have to attach the documents. I have to upload the documents. No higher lordship will get it. Money was there or not, this is the only question. Admittedly, money was there. There is no single column. Now, your lordship, kindly take note of the clauses, particular clause of the inquiry report. Kindly take up the book, my lord, page 1.89 for a moment. How the and which manner application will be inquired into. Page 1.89. From L. Have you also got my?
Yes.
But kindly see into application for FS dealership so and so, right so and so, name and so, details of hacker so and so. Inquiry report from top, from L. Now kindly turn to the second table, bottom, clause number 90. Whether the applicant has submitted bank details and you have verified, kindly take note of. On the date of inquiry. Next page. Whether the applicant is financially solvent as per order number so and so. On the date of inquiry, I produced, admittedly, they have not denied. And it appears on the last date of application, this money was there. This is the format for inquiry. It suggests on the date of inquiry, the inquiry officer shall verify the bank account. Kindly turn on serial number 20 and 21 on also. 21, in case of such account deposit is held jointly, NOC of sub judge holder for investment so and so. Permissible. They have verified my bank account, but since I have not uploaded, this is the only single ground. But these are my submissions.
Any clarification?
No. Please take down. Petitioner applied for FPS license in terms of vacancy notification number 2022 0022 3310. Vacancy ID notification number लिखा. Vacancy ID notification number. Vacancy ID number, not number. Dated 15th May 2024 by SCFS Dome call. Full stop. It is the case of the petitioner that he is the most suitable candidate, having spacious godown according to the notification, and he submitted the application along with application online along with all relevant documents. After submission of the application, his proposed shop cum godown was inspected by the concerned inspectors of Subdivision Controller Food and Supply Dome call. And when he was waiting for personal interview, it came to his knowledge that his candidature cannot be recommended on the ground that he is not a he is not a solvent candidate. It is the case of the petitioner that the petitioner used to maintain two bank accounts, one with IDFC First Bank being account number এটা লিখবেন বলবেন 10020 1002065 2266 and also he has a joint account with his brother নাম নেই কিছু নেই in State Bank of India, Sekpada, SEIKHPARA, Sekpada branch. কি বললাম বল কি বললাম Sekpada branch. হয়েছে? It is the contention of the petitioner that at the time of inquiry by the inquiry personnel, the petitioner has placed both the details of bank accounts, but the inquiry officers has only taken note of the bank account of IDFC First Bank. Full stop. He submits that admittedly the application for MR dealership was submitted by the petitioner on 7th of September 2024. Full stop. It is the further case of the petitioner that on 6th of September 2024, IDFC Bank in IDFC Bank, he has an amount of rupees 55,000. But on 7th of September 2024, some account was withdrawn. Some amount was withdrawn. Accordingly, the balance in the said account was 3,899. Full stop. He submits that due to sudden urgency, some money was withdrawn from the bank, but he used to maintain the working capital in the joint account. It is the further case of the petitioner that in the joint account, the balance amount was more than required amount of rupees 50,000. He submits that the petitioner has approached the concerned SCFS with the joint bank account, but his prayer was turned down verbally on the ground that the petitioner is the second account holder of the joint account, so his candidature cannot be considered, not said to cannot be considered. Ultimately, the candidature of the petitioner was rejected after filing of the instant writ petition. The state authority has used affidavit in opposition against the writ petition and placed the inquiry report. It is the contention of the state authority that during filing the application, online application, the petitioner has mentioned his bank account to be the bank account IDFC First Bank. Admittedly, IDFC First Bank. Admittedly, on the date of application, that is on 7th of September 2024, the balance of the said account was 3,899. It is the contention of the state authority that according to the eligible criteria mentioned in the impugned vacancy notification, an applicant must have a bank balance, must have a working balance of rupees 50,000 only in the form of saving account, current account at the date of application. The petitioner admittedly could not maintain such bank account. Thus, the inquiring officers, after detailed inquiry, has commented that the applicant is not financially solvent at the time of making application. Hence, the candidature of the petitioner was turned or was rejected. Full stop. Next paragraph. Mr. Saharai, learned senior counsel, appearing on behalf of the petitioner, submits that though the petitioner could not maintain the bank account of HDFC First Bank, HDFC First Bank on the date of application, but the working capital of rupees 50,000 is very well maintained by the petitioner through a joint bank account maintained with the SBI Sekpara branch. Full stop. It submits that the petitioner is otherwise eligible for getting the license, and he is quite solvent person to continue with the business. But the conduct of the concerned authority is not is irregular and not reasonable. He submits that the concerned SCFS and the inquiry team must have considered his bank account maintained jointly with his brother in SBI Sekpara branch. Next paragraph, learned counsel appearing on behalf of the state respondent submits that the concerned authority has acted according to the rules and proceeded to select the eligible candidates according to the control order as well as the vacancy notification. Full stop. He submits that vacancy notification has specifically mentioned about the maintaining bank balance of rupees 50,000 on the date of application. Full stop. The petitioner has admitted that on the date of application he could not maintain the bank balance of 50,000 in the account which he was mentioned in his application, in his online application. He submits that the concerned authority has not acted illegally or arbitrarily in rejecting the candidature of the applicant. Hence, this writ petition is not maintainable. Having heard the learned counsel for the parties, also considering the materials on record, it appears that the only single point is involved in this matter, whether the applicant, whether the candidature of the petitioner was correctly rejected by the concerned authority, while the petitioner could not maintain the bank balance of rupees 50,000 in the account which he was mentioned in his online application. Full stop. Admittedly, the petitioner has mentioned in his online application regarding his bank details to be a bank, to be IDFC First Bank, and it is also admitted that on the date of application, that is on 7th of September 2024, the balance of IDFC Bank of the petitioner was 3,899.81. Full stop. Next para. Roman 7 of eligible criteria. Point number 7. No, clause 7. No, sir, clause Roman 7 of eligible criteria of impugned vacancy notification of 15th May 2024. Read as follows. Bole eta tulun. 7. Etu. Etu. ঠিক আছে, page 19 of writ petition. এটু ঠিক আছে। The notification mention the eligible criteria that the applicant must have a bank balance of rupees 50,000. Full stop. So in terms of that eligible criteria, petitioner could not maintain the bank balance of at least 50,000 in the bank which he mentioned at the time of application. However, it is the case of the petitioner that he has placed the other bank details to the officers who went to inquire the proposed shop-come go down of the petitioner. However, the inquiry report was placed with the affidavit in opposition of the state authority. I have perused the inquiry report. It appears that the inquiry report has detailed about the bank account of the petitioner to be IDFC First Bank, Salt Lake branch, having balance of rupees 3,899.81. Full stop. The inquiry officers has not mentioned anything regarding production of other bank accounts within bracket SBI by the petitioner at the date of inquiry. It is the further case, it is the further case of the petitioner that though he approached the SCF's concern regarding his financial solvency, which he maintained at the time of filing application with the other bank within bracket SBI, but the SBI concern has not considered his grievances. Full stop. Let me consider whether the concerned inquiring officer or the SCFS concerned has any authority to accept the petitioner's grievance after filing of the application. It appears to me that there are specific provision in the Control Order 2013 regarding scope of inquiry and the format of inquiry report. It has been mentioned in Form L that in case of account holder, joint account holder, or for investment of with any other person regarding the financial solvency of any person, the NOC of the joint account holder required to be placed along with the application. In the present case, the petitioner has not placed any NOC of his brother. Moreover, he never mentioned that the brother of the petitioner who jointly maintain the bank account within bracket SBI has already handed over a NOC. Full stop. Moreover, it further appears to me that according to the notification, according to the vacancy notification, the each and every applicant has to furnish entire details of his candidature, of eligibility of his candidature through online. Full stop. After submission of such online application, his candidature and his proposed shop come go down has to be verified by the inquiring officer. At the time of verification by the inquiring officer, the officers are not permitted to act beyond the scope of the application filed by the petitioner, filed by the applicant. Extraneous consideration or extraneous document are not permitted by the inquiring officer to be accepted. If that can be done or allowed to be done, that would be out of the ambit of the notifications. Under the above observation, I am of a view that though the petitioner is otherwise solvent, but that cannot be considered by the concerned SCFS or by the cannot be considered by the inquiring officer or by the concerned SCFS at the time of determination, at the time of determining the eligibility criteria of the present applicant. Thus, I find no justification to take note of financial solvency of the present petitioner to other bank accounts for purpose of considering his application for getting vacancy, getting license under the impugned vacancy notification. Under the above observation, the instant writ petition appears to be not meritorious. Hence, I find no justification to interfere with the decision of the concerned authority. Disposed of.
Okay, grateful, man. I mentioned that.
Millard, 1000 apology, Millard. Item number 8 and 9, Millard, of today's list. Lordship knows, Millard, we are supposed to argue the matter on the point of maintainability. This point was never argued before any court. So we are prepared, Millard. We are stuck in the court number 37. While come,
One is there, I
Milord,
just,
this is I am taking the responsibility. Milord, kindly fix it up any day, Milord. I have seen, Milord. Otherwise, Milord, it will be in great difficulty. Milord. Kindly fix it up to, day after tomorrow. Tomorrow I have a matter fixed in NGT. Tomorrow at 2 p.m. I can come and
I
appraise.
have
And
already
one more
passed
thing,
order.
Milord. One
You
more thing.
just call Mr. Huda, if he is
Mr.
ready.
Huda, Milord, one more thing I would like to point it out. Milord, this is the convention and the practice that when a matter is being upgraded, this has to be notified to the other side by way of a notice. Milord, no notice was given to us. It was verbally informed to
Already,
us.
it was already there in the
Correct,
list.
but it was not indicated that it will be taken up at 10:30. That is the confusion we had in our mind.
No, in these matters, I always maintain the matter
I
first.
understand, Milord. I do appreciate. Milord, kindly, Milord, I will ask.
Okay, you call Mr. Huda, I will pass the.
My Lord, my
You
Lord.
call Mr. Huda, I will pass the order.
Deeply obliged. Lord, before Lordship takes up the next matter, item 11, my junior was there, but he forgot to give the appearance, Lord. In item number 11, Lord. There was a formal correction of spelling of the petitioner's name.
কে নিয়েছে ওই নিয়ে গেল তো এই 11 নম্বরে ওকে বলে দেবে তো জয়ন্ত সামন্ত লার্নেড অ্যাডভোকেট ফর স্টেট
I will hand you over the slip, Lord. Extremely grateful.
item number 11.
11.
Yes, next.
Petitioner,
I'm for the private respondent.
I am for the state in this matter, Lord.
I'm filing my opposition.
কোনো চাপ নেই। কোন matter এটা?
My lord, your lordship, I am appearing on behalf of respondent number 6 and I'm filing the opposition.
And I'm for the respondent number 5. I'm filing my.
Which for the petitioner?
I'm for the petitioner, my lord. My senior name is
Yes.
Microphone.
My lord, my senior name is code number 6.
So what can I do?
It has not yet filed.
My Lord, our not opposition, my Lord, reporting affidavit is being affirmed, my Lord.
Time may be given.
My Lord,
I reply.
yes, yes.
Matter may be fixed after petition.
Any day, any day. As per convenience of your lordship,
So affidavit in opposition by respondent number 5 and respondent number 6.
my Lord, may I have a copy of the same on both?
Both of you serve the copy to the state.
My Lord.
And I have submitted to the petitioner.
Okay. Please take down. Affidavit in opposition filed on behalf of the respondent number 6 and the affidavit in opposition filed on behalf of respondent number 5 are taken on record. Full stop.
Opposition I have submitted.
Copy served upon the petitioner as well as the state
Fine.
here and now.
Your lordship, respondent number 6 has also served the.
Okay, okay. The state respondents intends to file affidavit, report or affidavit,
Report on affidavit, it is being affirmed.
whether you filing report or
Report.
filing
Report in the form of
in the
affidavit.
form of affidavit,
My Lord.
intends to file report in the form of affidavit within a very short span, considering the submission.
My Lord.
Let the matter appear in the list 1 week after ensuing summer vacation for submission of report in the form of affidavit by the state authority, reply if any by the petitioner, reply stroke exception if any by the petitioner against the affidavit in opposition and the report filed by the respondents within 2 weeks after vacation. Let the matter appear in the list. 24th of June.
Ajula.
Well, under the same heading, man, that is my humble.
What? What for the same heading?
Mention matter.
my this,
Your Lordship,
Why in the mention matters?
but the
For direction for a
What is
file
the purpose?
but the only thing, may I just explain why this the private, when it comes to the private respondent, his candidature was cancelled by the state. In fact, my lord, it is only by way of an order of this honorable court that was quashed on a technical ground
You want
because
hearing of this matter.
hearing.
You want hearing this matter.
my lord,
So why the under mention matter?
mention
usually-
matters because this
I
was,
usually fix the mention matter, the motion matters, not the hearing matters.
but this is
Want to hear, want to conduct the
this-
hearing of this matter, I can fix specially for hearing. That is not under the same heading like
but
that.
that my lord will fix, but only thing my lord on the in the last order,
Matter is that the affidavit in opposition and the report and the reply has to be filed.
reply has to be filed, but this was report in the form of affidavit in opposition. That was the order, my lord.
Yes,
My lord,
they
yes,
have to file the report, and if you want to file exception, that has to be
But
done.
I'll have to
Not
file
file
my.
it, how can I fix the matter for
But
hearing?
my lord will kindly fix any date for hearing any if it's if
I
if a
allow
time
you
is
to
fixed-
mention any day after completion of pleadings, okay? Liberty to mention,
But liberty to mention
liberty to mention.
and go out of.
not go out of list, man. This is the private respondent is a person who is not even eligible. This person has played fraud on the government, fraud on the court, and now he wants the matter to go out of the list because he will continue illegally. He will continue with the
Not
shop. This
continue.
cannot go on, man.
If
He
wrong
cannot
submission, he's not
stay for a
continuing
single
even.
day.
I have fixed the date 24th,
Yes.
and I allow you, if the pleadings complete, you can mention earlier to that.
My
That is the order. So why you are,
The only
why
thing
you are not listening the order?
Orderটা আগে শোনো। Date has been specific date
Yes,
has been
I have,
fixed.
I have mentioned a specific date, and I allow you to mention earlier if the pleadings are complete. This is the issue only, and you are arguing otherwise.
All are in a hurry.
Yes, they are not ready to hear the orders.
I'm
Okay.
sorry, I tender my.
Next,
I am for the petition,
I'm for the statement.
but I am filing my exception to the report, and I am giving a copy to my learned friend.
My lord, I need a time, my lord. I have to go through this, my lord. Just now it has been handed over. I need some time.
I fix the matter any day as your lordship,
after vacation,
but before vacation, any day. Man.
how
Before
many days are
vacation.
there?
Monday, my lord, Monday. It should take only 5.
Yes, all the matter will take only 5 minutes or 2 minutes.
And continue for a
And
day.
I have only motion matters mounting.
Only fix it Monday, my lord.
No, no.
Or Friday,
After
this
vacation,
Friday.
after vacation.
Well, this Friday, but before any day before vacation, any day as your lordship. Any day.
I have only,
That's it will take not more than
7 working days perhaps.
no, not 7 working days.
Before
I
vacation.
have only
It will take 5 to
vacation
7 minutes, my lord.
4 days. 4 days for group 8.
For the in total
Only
7 days.
4 days
But
for,
it will
for
not
group 8.
not 10 minutes will time, not more than 10 minutes. I said, it's a very short matter.
Please take down. Accommodation is sought for on behalf of the state respondent to go through the exception filed by the petitioner today.
Today, my lord.
Let the exception filed by the petitioner be taken on record. List the matter for hearing under the hearing. Fix the matter for hearing, especially on 10th of June 2025
So great.
at 12:30.
At 12:30.
At 12:30.
My lord.
Great.
Next.
Deputy Lord, I appear on behalf of the petitioner.
Lord, I appeal for the respondent number 9.
But here, Lord, I have Lord, vacancy was declared. Last occasion, Lord, your lordship can recollect. Lord, vacancy was declared. I made application. Lord, hearing was given. Lord, notice was served to me. My application was rejected. I made an application under Right to Information Act. Last occasion, I have handed over 1 page. This saying that my application has been rejected, but no reason has been given. The lordships was asked me to verify that any reason is available in the website or not. But I have verified, but from there it is rejected. But only I find that rejection, no ground is there. So at this stage, Lord, I pray before your lordships kindly direct the authority to Lord the supply the copy of the rejection. What are the rejection application? Otherwise, I could not take any steps. Now this is the website copy. What I have found that.
Done, ma'am.
বাইরে ছিল তো
বাইরেই দাঁড়িয়ে ছিল
এই তো মাত্র ছিল দেখলাম সুমন আর এই যে
সুমন আর সম্ভূত দুজনই দাঁড়িয়ে ছিল বাইরে। In this matter, my lord, I appear for the response number 9. My lord,
Which for the state?
he is there.
is there.
But from the website, I have got this. Lord, if your lordship go through this. No ground for rejection has been indicated there.
My lord, so far as my lord, page 17, concern, my lord, page 17 is the advertisement. My lord, kindly sees clause V, clause, I mean, Roman 5. The licensing authority or the government in Food and Supplies Department reserves the right to reject any application or cancel the vacancy at any stage of the proceeding of the application without assigning any reason thereof, and will not contain the correspondence on this accord. Clause 5, my lord, page 17, my lord.
Not the page 17 is there. But we can reject without assigning any reason. The other thing is kindly take my paragraph 12 of the writ petition at page 9.
Yes.
My lord, paragraph 12 and my lord, there is paragraph 13. My lord, will find, my lord, they have not filed any representative before filing of this writ petition. My lord, it is a premature writ petition. My lord, they should first, my lord, approach the concerned authority.
Okay. We approach them with a representation and directing them. Okay.
As your lordship.
Okay. Very.
No representation at this.
I understand. Right. Please take down. Rebecca Khatun. Petitioner applied for license, a FPS license in terms of vacancy notification number such and such dated 13th of September 2023, page 14 of the petition. Full stop. After her application been accepted online,
Along with the requisite fees, my lord.
her proposed outcome go down was inspected and she was called in a personal interview by the concerned authority. He appeared in the interview, but subsequently it appears from the portal that her candidature was rejected without assigning any reason. Hence, the petitioner approached this court.
That apartment, if your lordship kindly take travel to see the advertisement itself. Advertisement, I believe my learned judges have shown. Accordingly, if that be so, there is no right has been accrued. Lordship kindly record to the text.
Okay. Full stop. হয়েছে? কি বলবো?
Page 17.
Hence, this petitioner approached this court for necessary direction upon the concerned state authority. Full stop. Learned counsel appearing on behalf of the state respondent submits that in terms of the vacancy notification,
Page 17,
vacancy notification,
Roman 5.
Roman 5.
vacancy notification part 5, clause number 11, subclause 5. The licensing authority or the government in Food and Supply Department reserves the right to reject any of the application without assigning any reason. Without assigning any reason. Full stop. Thus, the petitioner has no locus to file the instant application. Moreover, his candidature, his Moreover, the decision for rejection of his candidature not require any reasons to be assigned to the petitioner itself. Full stop. Learned counsel appearing on behalf of the state authority also submits that no representation are placed before the concerned authority regarding the grievances of the petitioner. Hence, the instant writ petition is premature. Premature one. Having heard the learned counsel for the petitioner, learned counsel for counsels for the parties, it appears to me that the candidature of the petitioner was rejected by the concerned authority. The information was received by the petitioner through online portal. Full stop. It is true that in terms of the notification, the licensing authority stroke the government is not duty bound to assign any reason for rejection of the candidature of any candidates. But that doesn't mean that an individual who applied for license cannot approach the authority. Full stop. However, considering the aspect, considering the aspect, the instant writ petition is disposed of with a liberty to the petitioner to approach the concerned authority with a proper
Response number 6.
authority.
We apply before the response number 6. Subdivisional the controller food and supplies.
Authority to representation for his grievance, for her grievances. Full stop. The subdivisional controller food and supply, Malda Sodor, being respondent number 6, shall dispose of the representation of the petitioner within 6 weeks from the date of filing of the representation to the authority. After giving the appropriate opportunity of being heard to the petitioner. Full stop. The decision of the authority shall be intimated to the petitioner within 2 weeks thereafter.
Lordship, the opportunity of the hearing to the petitioner. In my respectful submission, that we not suffice to provide the reasons, like was the score sheet of.
I do not know what is.
Why I am saying so. This is a non-statutory representation. First of all, which is the first hurdle which he has to cross, that once he has participated on the selection process, I have shown the clause. Therefore, the right which has been accrued or agreed, he is not coming within that ambit. So no. Instead, what I'm proposing to develop, instead of without giving opportunity, kindly direct them to apprise him the reasons. Because otherwise, what will happen?
Today we do not know what the grievances are.
Correct.
Okay.
What is his
so let them ventilate her grievances to the concerned authority. That may be not within the parameter of the writ petitions also.
May I just only one thing with your lordship, kind consideration. The flip side of the coin is something different. Just flip side of the coin is that once lordship is passing the order, there are two things. One is non-compliance of the order, which would be giving the birth of a contempt to a petition. Second, once the reason has been given, although there is no scope, second writ petition will take a birth.
Yes.
Why?
No, if they have rejected, no, kindly see there. But I have made application.
Why?
I have deposited the deposit fees.
Let me understand. I could not understand the issue.
I tell your lordship. There is a tender. In the tender clause, the authority stated that whoever can join the same subject to the satisfaction of the authorities.
Yes.
In the part 5, it has been also indicated that we are not duty bound to assign the reason to the individuals for the purpose of rejections. Now he says that what is the purpose of rejection, I do not know. The procedure is that once the individual has the applied on the same, on his own opinion, if he can open the same, he will get to know the reason, not the others. Now today he is saying, look here, I wanted to know the reason. First of all, there is no representation. Lordship knows mandamus cannot be issued without a representation. Lordship knows far better than I do. Second, Lordship is giving the opportunity of the hearing to the petitioners in order to know what are the reasons. Now, here is the catch. Catch is that Lordship is giving a time-bound period for doing the same. If supposedly otherwise we could not perform the order, otherwise kindly do not take me otherwise, we are always duty bound to comply the order. Supposedly, if it is not been done, then it will give in birth to the contempt. This is one part. Another part of the coin,
6 weeks.
I just for the argument's sake, I kindly do not take it as an admission. Assuming, second, he will get an opportunity of the hearing. He will come to know of the same. This will give in a birth to the another writ petition.
For what?
He would say, this is not the thing, this is not the way to reject the same. That is why in the tender proceedings, if Lordship has vast experience in the tender proceedings, starting from Tata Cellular to everything, if there is no arbitrary proceedings to rejecting the same.
I have not entered into the merit together. Today I have not entered into any of his actual claims.
Hearing, kindly appreciate. Lordship is giving the hearing on the basis of the rejections. That is the troubling us. Because today,
why troubling you? Why is they troubling the authority? The person will appear before the authority, and you will furnish that reason. That's why you.
If your Lordship sees, if your Lordship allows this application, that this representation would be considered in accordance with the law, up to this is all right. I have no objection.
That is the order.
Yes, but if your Lordship's opening the floodgate, like by giving an opportunity of hearing to the other side, and giving the show cause of the such and such, that is mean violating this clause.
Okay. So you are violating natural justice.
Natural
justice, not to giving any party.
Natural justice. My lord, with due respect, I have a very limited knowledge of the law of the law. So for the natural justice, is there any straitjacket formula? I am asking myself. This is number one. Second, once a person has been accepted the same, accepted the condition, in that event, it is coming to the approbate and reprobate. He cannot turn back and say, kindly give me the reason. Kindly appreciate on this aspect.
Okay, I understand.
Yes.
Not only one thing what I am submitting, a reasonable opportunity to be hearing to the interested parties into the petitioner.
No, not interested party.
Difficulty will be kindly similar. Whatever they want, they can write in a paper and send to the petitioner.
Okay.
I should have been granted an opportunity of hearing since
Yes.
I am the last.
Interested parties, my lord.
কি বলো? Petitioner according to the law.
Yes.
Petitioner according to the law.
The petitioner and the interested parties.
As early as possible. Why interested parties?
Otherwise,
no one is interested.
Because I have made a private respondent. That's why, my lord.
Very good.
According to law. According to law, within as early as possible, most preferably within 6 weeks from the date of filing of the application.
And that should be communicated to us.
The decision of the authority shall be intimated. Decision of the authority shall be intimated to the petitioner within 2 weeks after taking the decision. Under the above provision, the instant writ petition is disposed of. Full stop. I make it clear that this court has not entered into the merit of this matter. The concerned authority shall dispose of the presentation according to the law and according to the notifications. According to the impugned vacancy notifications. Without being influenced by any observation of this court.
Thank you, Lord.
Deeply obliged. Kindly do not take me MS,
No,
Milord.
not at all.
No,
This is,
representation
Milord,
is to be-
sometimes what happened,
This
sometimes
this is the way to develop the law.
my lord, this is the clarity I should also, Milord, know if I am making any mistake. Milord, kindly do not take. And Milord, one more thing, Mr. Huda, I have informed. Mr. Huda has informed my junior that he is now in the commission. He will come back. So in that event, what is
Okay,
my
okay. I have taken your submission. Let Mr. Huda appear before me. I will fix any date.
any
before-
date, lordship, 7 except
because
tomorrow?
these matters are running for
I
quite
understand.
days. You understand the matter.
Lordship, kindly
At-
hear
at
it
1
today itself.
I fixed the matter today for hearing the matter.
No.
And you are not there. No one there to see. You are
Milord,
entertaining where?
what would I say,
I
Milord?
just wait for some
The
time.
word is very feeble to express my apology, Milord. Word is very
One is
feeble.
there. I think Mr. Sengupta has
Milord, I am
interest,
extremely sorry.
interest in this matter.
Generally, Milord, Lordship would not believe from the last 1 week, we and Mr. Dotto were researching to the same.
Okay, that's why I have given the opportunity
My
to hear
lord.
the matter. I know that
Kindly
you know.
fix it any day except tomorrow, Milord. I will come and argue.
Okay, Mr. Huda, let Mr. Huda
Very
come.
well. Kindly, in the meantime, kindly do not sign the order, Milord.
I have not signed till
Yes, kindly do
not
not
yet
sign.
signed.
You are
Yes.
granted liberty, my lord, to us to make an application within certain period, my lord. Within 10 days or 2 weeks.
No, I have not given you any opportunity to file it when you want. Yes, next.
আমি জন্মালো না রামায়ণ হয়ে যাবে গো।
I am for the petition. I appear for the state respondents. But petitioner before your lordship is a fair price shop owner.
Yes.
So cause notice has been issued. Petitioner submitted reply denying all the allegations. Ultimately, order imposing fine has been issued. Initially, order of fine of rupees 3,88,065 have been issued. Thereafter, petitioner preferred appeal before the appellate authority and the appellate authority. Then second appellate authority by an order dated reduced the amount from 3,88,065 to 3,88,735. Page 30, that is the order passed by the second appellate authority. Page 30.
3,88,000 to 2,88,000.
3,88,065 to 2,88,735.
Yes.
What happened? Part is very meager. Sir, paid for installment. Only I am paying is a margin petition. Paid for installments of the amount. Nothing more, nothing. It's not that petitioner don't want to pay, the same or challenges the order. Sir is paying for installment of these amount. Only thing. Kindly come to page 33. That is my representation. May I read my report?
So who passed the order? Appellate authority.
Director of Ration.
Director of Rationing. So you have to approach the director of
I
Rationing.
have approached. Ultimately, the amount has been reduced from 3,88,000. So far, the
He wants more.
20
Penalty amount reduced, then appeal.
1 lakh.
Yes.
has been reduced. Initial
Now he wants installments to pay the penalty amount.
Whatever maybe that will be decided by the director who has passed the order.
Yes. That
Relegate the
will be
matter.
left to the yes. Lordship may not.
Relegate the matter
Yes.
to the director. He may deal with the
Yes,
matter on
yes,
the
yes.
Ultimately, what happened, my lord? It is 34. Rationing officer rejected my such prayer
Okay, it was rejected.
by the rationing officer.
Why you approach the rationing officer? Rationing officer is not the person.
I come to page 65, 35. I have approached before the director of rationing.
Yes. That was not considered.
That has also been rejected.
That was rejected.
Yes, ma'am.
Where is the order?
39.
Joint director rationing.
That has been communicated. My address appeal was to the director of rationing. Page 35.
Read out the order. What is the order?
The undersigned is directed to inform that your second and final appellate authority has already considered dispute of your appeal as per the provision of the corresponding order urban public utility for maintenance 100/30. This is for your, there is a further scope to consider your prayer under existing provision. Fourth, your prayer is thus turned down. You are directed to comply with the order. That has been turned down. That is the challenge for your law.
But he cannot, my lord, claim compassion, my lord. He is already he has already been penalized. Now penalty amount has been reduced by the first, second appellate authority.
Considering the appeal that has been lowered down, not reduced. There is no mercy to that effect. That they have shown some mercy that according to it. There is a calculation.
It's a kind of mercy. Now if penalty amount is reduced, it's a kind of mercy.
I am ready and willing to pay the amount. You must kindly come to my representation once. What I am saying, what I have said. Page 37.
What is your representation to the director listening regarding installments?
Yes, sir. Page 36. I am ready and willing to pay in 5,000 per month.
5,000 per month.
Is my prayer.
But wishful, one not think wishful.
My prayer.
This sort of a penalty has been already rejected. Lordship sees the 23rd April 2025 order. The Joint Director of Rationing said that second appellate authority considered and disposed of the appeal petition as per the provision of the order 2013. It was conveyed that there is no further scope for considering the prayer under the extant provisions of law. After that, he has exhausted all the remedies. Now he is before Lordship, but the Lordship may not delve into the domain of the authorities.
Must apply for the equal installment of within some times, but not fixing the amount of money. How many time will require to 1 lakh, 2,88,000,
2,88,000.
5,000 per month means?
That is my prayer. That is my
This is
prayer.
unreasonable prayer, Lordship. Yes.
3 to 4 years will require.
In other cases,
কত বছর ধরে
says without exhausting any remedies. Now we are exhausting all remedies coming for this court.
Now the court, reach court
Yes.
possibly may not have the.
Now we are exhausting all remedies. Make it 10,000 per month.
I'm not saying anything.
I'm not
If a Lordship passes any order, but here, I am opposing the prayer. This cannot be done by the reach court. Otherwise, there will be a floodgates. Everybody will come.
I am not paying for
The
any
reduce-
reduction of money.
Once compulsion has been shown to the 1 lakh has been reduced, the penalty amount.
I am relegate the matter to the director to fixing a time.
But better your lordship send it to the secretary because director has
To
already decided.
conclude the entire amount to be done within such period, not the amount of month or amount of money like that.
I
Say within 10 installments, within 15 installments like that.
Your lordship may fix the time installment.
At
What
it-
are your lordship suggestion? I am not standing on that.
Equal installment on the time.
Any installment.
No, I relegate the matter to the director to fix the installment.
Because it is the order of director is on the challenge.
Yes.
So, liable the to reconsider the matter. Reconsider the matter.
I relegate the matter to director to fixing the installments.
Upon reconsideration of the whole
Yes,
matter.
yes. Okay.
Comment কি হবে? কত কি হবে? শুধু
Please take down. Petitioner is running a FPS dealership under concerned Food and Supply Department. A sudden inquiry was conducted by the officials of Food Department, and a huge amount of money was imposed upon him as a penalty. The penalty amount was 3,88,065.
Get this 25.
By SCF is concerned,
National officer, Asansol 2.
by reasoning officer Asansol 2. Against such order, the petitioner approached before the appellate authority, being the deputy director reasoning, who after hearing the petitioner has reduced the
So, confirm the order of the national officer.
okay, confirm the order of the reasoning officer.
Page 26.
Against such order, he approached the director
Director of national.
of reasoning
Taken appellate officer.
in through a second appeal. After hearing the petitioner, the director of reasoning has reduced the penalty amount to the tune of rupees 2,88,735.
Page 31.
Yes. The petitioner has accepted the penalty amount and submitted a application before the concerned reasoning officer so that his penalty amount may be remitted through installment of rupees 5,000 per month. It was not considered. Thus, he again approached to the director to a proper representation. The director of reasoning did an order dated 23rd April 2025. Turned down the prayer for installment with a ground that within inverted comma there is no further scope to consider your prayer under existing provisions in force. Inverted commas. Hence the instant writ. Petitioner submits that his financial condition is very poor. It is not possible for him to deposit the entire amount of money, for which he shall suffer irreparable stringency, financial hardship. He submits that necessary direction may be passed upon the concerned director's reasoning so that his representation may be considered. Mr. Dr. Learned Counsel, appearing on behalf of the state authority, submits that that there is no scope to consider the representation of the petitioner. He submits that through appeal about 1 lakh penalty amount was reduced. The petitioner is quite capable to pay the penalty amount. Thus, his prayer cannot be considered. Or the learned counsels peruse the submissions as well as the pleadings of the petitioner. It appears that the petitioner has pleaded that he is financially poor and his physical and he is also suffering some physical illness. However, it appears from the representation that petitioner approached the concerned director DDPS so that the fine amount may be remitted through easy monthly equal installment of rupees 5,000. Rupees 5,000. It appears that if the entire fine amount is being remitted through wide equal installment of rupees 5,000, at least 3 years would be required. 3 years would be required to remit the entire amount. No, at least more than 3 years. Considering the situation, the prayer of the petitioner cannot be considered in such a fashion. However, the concerned director reasoning may allow the petitioner to remit the entire fine amount within 2 years by equal installments, equal monthly installments. Full stop. However, the entire decision is upon the. However, the decision has to be taken up by the concerned director of reasoning. Hence, I intend to relegate the matter to reconsider the prayer of the petitioner. Under the above observation, the writ petition is disposed of with a direction to the disposed of with disposed of with a direction to the director reasoning to reconsider the proposal of the petitioner for remit the entire fine amount through equal monthly installments to be fixed by the concerned director of reasoning. Under the above observation, the impugn order dated memo dated 23rd April 2025 is set aside. Full stop. The petitioner is directed to approach the director of reasoning within 2 weeks from the date of within 2 weeks from the date of passing of this order. Full stop. The director of reasoning shall dispose of the representation of the petitioner within 3 weeks from the date of filing of the representation. Decision of the authority shall be intimated to the petitioner within 2 weeks thereafter. Under the writ petition disposed of.
One.
By director of reasoning, they shall not take any coercive steps for taking money from the petitioner. In terms of the order of the, they will not take any coercive steps if the decision being taken by the director of reasoning.
What coercive steps?
They will terminate my license for not making payment of the amount. There is provision for terminating my license for not making payment.
Now, Lordship has been pleased to direct the authority to consider, but the Lordship has been pleased to direct to grant them installments at the same time. I find from your Lordship's direction the operative part. It has to be done within 2 months.
Installment
within two years instead of 3
maybe
years.
within 2 years.
Maybe
Within 2 years, it would be entirely upon the director. Not like that.
Also, can add one line that the authority will not be influenced by the observations of the Lordship, if any, and according to law. And my Lordship kindly records that I am not admitting any of the applications because affidavit has not been called for.
Okay. No. I make it clear that this court has not entered into the merit of this matter. The director of reasoning shall dispose of the representation of the petitioner according to the law without being influenced by any observation of this court. Full stop. Next para. Since no affidavit, no affidavit has been called for, the allegation in the writ petition shall be deemed to have been not admitted. Full stop. Till such decision be taken by the concerned authority, no coercive action shall be taken against the present petition. Next.
Lordship.
পাইকারপুর প্রভাতী গোবিন্দনগর আইদা উত্তর বনানী কেশবপুর শ্রীরামপুর নারায়ণপুর নারায়ণচক দক্ষিণ বনানী হাসনাপুর and Muslimla by making doorstep delivery to the beneficiaries under the ration scheme manner, and there is no complaint from any party. And manner it has a catering about 8,200 ration cards. But thereafter, manner sometime in 7 June 2022, manner the vacancy notification was published in that area, manner seeking for curtailment of certain ration cards, manner. Against that manner, against that vacancy notification, manner, the petition was challenged that manner and taken
one. This is page 22, na?
24 January 2023, manner.
Yes,
and it's a
P2.
Page 22, manner.
Yes.
The not to curtail dealers, manner. Order was manner. And it comes to page 23.
Yes.
I'm done reading from page 22, manner.
May I assist your lordship?
Direct counsel appearing on behalf of the petitioner submits as follows. The petitioners are a fair price shop leader at village and post office Harishpur, Kotwali, police station, such as. They have been running their shop since quite some time and their license have been renewed up to date. In all, they are having 7735 number of ration cards tagged with them. It appears from a memorandum dated 11/2/2022 of the Food and Supplies Department that according to the new policy of the state government, if a fair shop has cards in the range of 5,000 to 6,000, then there shall be a scope of declaring vacancy for such area. It was also decided that a new fair price shop shall start with a range of 3,000 to 4,500 ration cards. So far as the petitioners are concerned, 77 number of ration
अभी
cards
देखो
having been
currently कितना है?
for within the range of ration cards which can be retained by an existing fair price shop. If a new fair price shop is started in the same area, then it would not have cards in the range of 3,000 to 4,500. Otherwise, the cards in the existing fair price shop would fall below 5,000. Therefore, vacancy could not have been declared for the same area. Number that there was direction for affidavits, manner and manner. It was said that the state undertook that no adverse steps to be taken in this regard. And one of the interim order was extended, my lord. So, my lord, the petitioners till date, my lord, they are enjoying that number of ration cards. Pursuant to the order of thereafter, my lord, the petition bench order has been passed, my lord. Now, my lord, kindly come to the impugned order, my lord, Annexure P4, page 28. This vacancy notification has been published on 20th November 2024. And against the same area, my lord. Kindly come, my lord. Location is nearby Vrindavan Park, and my lord, service area is Hosnabad, Narayanpur, Narayanchok, and Sridampur. So, my lord, the petitioner is catering the ration cards of this area, my lord. So, my lord, now, my lord, if this vacancy is if the vacancy is given effect, my lord, if the particular is selected, my lord, then one of the petitioner's ration cards will be unviable. Moreover, my lord, kindly come to, as your lordship knows very well, my lord, that rationalization policy was made, my lord, on 3rd September 2021, my lord. 3rd September 2021, my lord. And my lord, kindly come to page 34, my lord. There, my lord, it was declared. It is to be kept in mind that in this exercise, a certain range of ration card population between 6,500 to 7,000.
No, thereafter 22 order was there,
Yes.
and 23 order is also there.
Yes, yes. All modified orders are there.
Yes. So now, what is your grievance?
I have challenged these orders also, my lord. My lord, page 40, that is under challenge, and as well as page 39, my lord. These are also under challenge, my lord. Says, my lord, the director has no power or jurisdiction to issue these orders. Prior to that, my lord, I would like to place, my lord, 3rd September 2021 Policy.
I know that order, policy order.
Your Lordship knows, my lord, only this portion, my lord, I want to just bring it to your page 34, my lord. It is to be kept in mind that in this exercise, a certain range of ration card population between 6,500 to 7,500 considered to be minimum average. So this was considered to be minimum average, has to be kept written with the existing FPS while exploring rationalization.
That is 2021 order.
Yes, my lord. That is
Thereafter 2022 order.
passed by lord by the director, DDPNS, who has no power and the jurisdiction, my lord. Only mere approval of the secretary does not give the director to change the policy, my lord. Policy of rationalization. So, my lord, this is also under challenge, and my lord, the vacancy which has been declared now in 2024, my lord, seeking to curtail certain dealers of my dealership, I will be again affected.
So after cutting, what would be the amount? What would be the DRC with you?
My lord, there is the direction.
Let a report be called for.
There is the direction of the honorable division
The
bench.
other matters, I
Yes,
call
yes.
for the report and dispose of the matter.
My lord, since there is a direction of the honorable division bench, my lord, not to curtail dealers. Not to
Lordship,
curtail-
may I,
That is 2013 control order, not the 24 control.
Lordship, let me come back with a
Yes, you
report
come
and
with a
or
report,
I
short report.
short report. I have one copy. If Lordship wants me to place it, I will. But I think it will be better if I place it in the form of an affidavit because it is a very bulky instructions. Lordship can see it is starting from writ petition 1337. All the orders annexed. Then it goes to Honorable Justice Vivek Chaudhary is passing an order where he disposes of the application, and again this new thing coming into play. If Lordship allows, I can, or otherwise, just give me 1 or 2 days. I will come back prepared and I will argue this matter. I leave it to your Lordship in every
My lord,
circumstance.
This issue, my lord, the 2013 control order, my lord, and that is, my lord, is yet to be determined by the honorable division bench, my lord, as your lordship knows very well, my lord. Now, my lord, 5,000 ration cards also, my lord, that is also, my lord, below, but that has not yet been. That is why, my lord, I have brought to your notice, my lord, the policy decision of 2021, my lord, where it was very clearly, my lord, stated that minimum average should be 6,500 to 7,000. That is the minimum average. And, my lord, that was passed by the state.
No,
That was passed by the
it is not
state.
required that
My lord-
all orders should be passed by the secretary or signed by the secretary.
But, my lord, the
It
director.
has to be signed by the director. All the official
My
may
lord-
be signed through
No,
the official correspondence
But
and
my lord,
official
this is a policy decision, my lord, cutting of ration cards. My lord, this cannot be
routed through
decided.
the files.
My lord, this cannot
All routed through the file decisions.
No, my lord, this cannot be decided in this way, my lord. The director has no.
Let them file the
Let
report.
yes.
Let them
Let
file
us
the
come back
report.
and let us
So the
see,
only particular
Yes,
challenge
yes.
is that
whether
whether the order
yes can be passed by the director. Yes.
or whether it is the decision of the
Yes,
state.
yes. This is what I could make out from
Terms it had been defined as the
Yes.
decision of the
And
state.
my lord,
this is
there
what
was
I could make out from the arguments advanced by my learned friend. So rest of the arguments which he has made, I can counter it with the instructions that I have over here. But what he has stated that the director has passed this without jurisdiction. Now I need to come back on
Yes.
this.
And my lord, one more thing, my lord, state has also taken, my lord, has given undertaking that no adverse steps shall be taken in case of the petition, my lord, in the earlier writ
In
petition.
earlier writ petition,
earlier writ
Lordship,
petition, which is still pending, my lord, which is still
and
pending.
kindly sees after that many orders were passed. I'll
Kindly come to page 23, my lord. It's my lord, if a new fair price shop is started in the same area, then it could not have been with the existing fair price shop would fall below. Therefore, vacancy could not have been declared. Learned
You have
counsel
challenged the
have-
13 control order.
Yes, my lord, but state has stated, my lord, state
Now
has,
new vacancy notification, new cause of action.
my lord, state
You
has
want new
undertaken that
order.
no adverse steps would be taken in this regard, my lord. My lord, in curtailing the ration cards, my lord. Even though they have declared the vacancy, my lord, under 2024 control order, my lord, a new control order, my lord.
Very well. Okay, I understand.
But Lord, the policy
let me
is
come
under
back.
challenge,
Let
my
me
lord.
come back.
Order
This is
of the
under challenge.
director.
Let them
Yes,
file the report.
let us come back.
Let the file the report. Please check it. Having heard the learned counsel for the
Specific
petition of the
instruction.
parties, it appears that this matter cannot be disposed of without giving
Jurisdiction क्यों नहीं है?
opportunity of
Director
the
का क्या
state
provision?
respondent to file a report in the form of affidavit. Let the report be filed within
In the meantime, my lord, no adverse step
within a
should be
week.
taken.
Within a week after vacation.
Yes. But only after the 16th of June because I'm out of station, Your Lordship.
Let the matter appear in the list on 18th. Under the same heading.
In the meantime, my lord, no adverse step should be taken, my lord.
In Lordship, may I
May-
most
may-
humbly
may-
mention?
Because my
Why?
writ petition will be infructuous.
No, Your Lordship,
now?
no, no.
But
In
the
that
issues are
case,
pending.
their liberty should be given
One of
to
the
them
issues
that
are
if any
pending,
such
one of
situation
2013
arises, they be
the
at
issue
liberty
is
to
still
mention.
pending. They have again declared in the same area, my lord. Kindly, my lord.
No,
Yes,
no, no,
only
no,
my
no,
lord,
Your
I
Lordship,
agree
I'm
In these
nothing
matters,
but-
I could not. I
Yes.
never pass any order
Yes.
like that.
There will be no adverse step.
No, no,
Only
no, no.
this one.
No, Your Lordship,
No
in
adverse
that
step.
case, if
First
something,
step means what?
But they will
They
not
will
cut off
proceed
the
with the selection process. That is the issue.
My lord, they will not, it was their undertaking, my lord, that they will not curtail dealers from the petitioner. It is their specific undertaking, my lord.
If
Kindly.
there is
Let me-
undertaking, let them. You can bind them there.
this will become even
Bind them there.
more dangerous if we do that.
Let there be an order.
Kindly, Your Lordship,
Interim order. I
Let
am
this
not
be
passing
recorded.
such interim order.
Let
Kindly
this be
come- let
recorded,
us
my
come
lord,
back
that,
with the report, Your Lordship.
no petition is taking, my lord. Let this be recorded.
kindly, Lordship.
No,
Otherwise,
in these matters,
take, my lord.
I cannot pass any.
Then, my lord, the 2013 control
No,
matters
I have
will go
disposed of
infructuous.
certain matters in these in like that fashion. I have not passed any interim order in any of them.
And their team is always knowing better than us.
Okay, very well. No interim
Your
order.
Lordship.
Next. T. You have 30 matter. Yes, doctor. You have 30 fixed matter is there.
19.
You have 30 fixed matter is there. Let me call that matter.
This matters my last occasion, Lord sir. I am sorry to report. The original report is with me, man.
Who is for the petitioner?
Niranjana Agga is appearing for the petition. The HON'BLE.
My last occasion, Lord sir, petitioner's arguments were concluded, man.
Yes.
Yes.
Yes, Mr. Chatterjee, what is the matter?
The matter is regarding to the challenging the declaration of the vacancy, and the private respondent was appointed as an FPS dealer. He is challenging that. So 2 or 3 grounds is taken by the petitioners. First is, my lord, the go down is concerned, and he is a better candidate than the private respondent. But the report says that he is not an eligible candidate because 200 square feet minimum scope is not. He is not possessed 200 square feet. 120 square feet is there, my lord. Kindly recollect this report, my lord. And the last, my lord, there is one point is there the lease executed by the private respondent with the others. He is in the lease is not proper lease, my lord. That though is a registered one, my lord. If my lord, I am relying my affidavit of report, my lord. Page 2 of my report, my lord.
Yes.
In cancellation or earlier notification number such and such dated 7th February 2019, a fresh vacancy notification of fair price of situated at central point of vacancy location at Rampur, Polli Mongol, Juva Samiti, White vacancy notification number 5 such and such dated 7th 2022 was declared by the Subdivisional Controller Food and Supplies Chanchol after getting approval from the Department of Food and Supply, Government of West Bengal under West Bengal Public Distribution System Maintenance Control Order 2013. The said vacancy was advertised in widely circulated newspapers, and petitioners Mohammad Sami along with the others 5 applicants had applied for the said vacancy. After receiving the application and getting appointment as an FPS dealer, a field inspection and spot inquiry was done by the inspector FPS under the supervision of the ACFS Chanchol, and said team thoroughly inquired the applicants who applied for the same in respect of the nature of land area and land in condition of the godown, storage capacity, financial solvency, and other criteria which are necessary for the selection of the new fair price of dealership. It is specifically mentioned herein that after conducting a thorough spot inquiry under the supervision of Subdivisional Controller Food and Supplies Chanchol and also relying on the submitted documents through online process, the inquiry team prima facie come to finding that Srimati Lakshmi Das stand in the Lakshmi Das minor is the private respondent, and he also selected as an FPS dealers. A better position regarding the area of condition of godown, storage capacity, and others criteria established a new fair price of. On the other hand, at the time of inquiry, it has been found that petitioners herein shown proposed area of godown and fair price of was 463 square feet and 122.72 square feet. My lord, I am emphasizing the 122 square feet. Lordship, my lord, kindly peruse that vacancy notifications.
200 square
200
feet
square
is
feet minimum criteria. And the threshold, my lord, the petitioner application is not entitled. At the threshold, he is ineligible, my lord. The respondent number 10 has taken the godown, but on the other hand, it reveals from the inquiry report that Srimati Lakshmi Das, private respondent herein shown proposed area of godown and fair price of sale counter of 425 square feet and 209 square feet respectively, which is much bigger and appropriate in terms of the vacancy notification. Respondent number 10 has taken godown on lease from Abdul Hassan, and it was registered before the additional district sub-registry office, Malda, my lord. It is pertinent to mention that as per the notice in spot inquiry held on 18 October 2022, and after conducting through spot inquiry, it was found that the petitioners converted living room. That is the efficiencies of the petitioners. Petitioner converted living room, proposed subcom godown. It was revealed from the proposed godown is not single compartment. That is the godown has 2 compartments. First part of the godown has backdoor entry, and that is not permissible under the law. For this reason, the proposed godown is suitable for the storage of food grains. It is specifically mentioned here in that pursuant to the vacancy notification dated 7 June 2022, applicant should possess a suitable godown and subcom room, office space, and cell counter of godown should be minimum 400 square feet, and the sub room office space should be minimum 200 square feet, which used for the office purposes, which specifically mentioned in part 2(4) of the above notification. But Mohammad Samim, the petitioner, has failed to comply the required minimum criteria of 200 square feet proposed subcom godown, and he is possessing 122.72 square feet. My lord, I am relying the inquiry report. My lord, in page 10, my lord. Page, my lord, 12, my lord. Clause 50, my lord. Details of the subcom godown proposed determination.
Petitioner.
My lord, yes, my lord, petitioners. Dimension of storage godown, my lord. Area 463 square feet. Character of the land of the premises Vastu. Size of cell counter 122 to 70 square feet, my lord. The storage capacity, my lord, GPS location is there.
Comment for suitability.
Comment on suitability, the application convert living room. My lord, kindly 54 distance 150 meters, not applicable. Comments on suitability, the applicant convert living room to godown. The godown have 2 parts. First part of the godown has back door, and the roof is corrugated sheet roof, and second part of the godown is concrete. Hence, the proposed godown is not suitable for storage of food grains. And that is a comment, my lord. And overall comments, my lord, 65 last. The proposed godown is not suitable for storage of food grains. The area of proposed cell counter is less than the government orders. The applicant did not submit the affidavit shown before the magistrate court And as per the my lord, the requirement, there is an annexure PO. And in view of the above, the applicant unable to fulfill the eligible criteria of engagement of new FPS dealers, hence the applications may not recommended. And my lord, otherwise, my lord, the private respondent herein, my lord, page 14, the report of the inquiry report, my lord. Page 16, my lord, details of the SOPCOM go down, 425 square feet, the storage of the godown capacity and the character of the land and the premises is Bastuman. Size of the cell counter 209 square feet. Whether godown and cell counter are adjoining, yes. Whether the construction godown of the counter of Paka, yes. Whether roof of corrugated sheet, whether measurement instrument are calibrated, not available. Whether the wide on approach road, that is the also is question that the approach road for loading and unloading there is insufficient. But the report is says otherwise. Whether the wide and approach road is sufficient for loading and unloading for food gain, 18 square feet. Whether the premises is free for encumbrances, yes, my lord. Storage capacity of the godowns 370 in quintals, my lord. 57, my lord. Rental possession. Names of the owners of the godown: Abul Hossein. Number of date of execution of registered tenancy deed with the applicant's date 9 September 2022. Period of lease 10 years, my lord. And whether expiry of rented or yes is rented, whether ROR of the owner of the lease or tenancy agreement, up to date rent receipt have been verified with original signatures, yes. Comments, my original verified registered deed, property and tax deed is Porcha regarding land documents at the time of inquiry, that was, my lord, verified with the original documents. Any documents not submitted, no. In view of the above, the applicant fulfills all the eligible criteria for engagement of new FPS dealers, hence the applications may be recommended. This application was recommended. My lord, next page, my lord, there is a sheet of the tabular sheet, the marks obtained by the petitioners. Petitioners obtained, my lord, 58 marks. The inquiry officials and my lord, the private respondent obtained 55 marks. Marks given by the district level fair price of selection committee, petitioners obtained 10 marks and total he is getting 68 marks. And private respondent getting 19 marks from the district level fair price of selection committee, on aggregate he is getting 74 marks. And he is much better than the petitioners. Page 7, my lord, it is specifically mentioned here in that after complying inquiry of all the applicants by the incorporating authorities and submitted report before the competent authority, does as per the details. My lord, page 7 on my report, my lord.
Page 7, yes.
Para 5, my lord. It is specifically mentioned here that after completing inquiry to all the applicants by the inspecting authority and submitted report before the competent authority, that as per the details provided in the online report and provided by order number 2750 memo dated 17th August 2022, score sheet for all applicants were generated online for the total of 75 marks, and considering the marks obtained by the candidate, the most suitable candidates were recommended by the SCFS. Therefore, score for the remaining 25 marks was given by the district level fair price of selection committee. From the score sheet, it is clear the district level fair price of selection committee recommended candidate Lakshmi Das has obtained 74 marks. In total, an incumbent Mohammad Samim had obtained 68 marks only. The main difference is marks between the two candidates are size of cell counter and shop 8 marks versus 5 marks given by the district level fair price of 17 marks and against the 0 marks. The applicant with this higher score was thus recommended by the district level fair price of selection committee. Then the case moved before the online for the district level fair price DCFS and DDPS department for approval. A copy of the said score sheet, I am perusing the score sheet, my lord. Lordship sees that all along the petitioners and the private respondent getting better marks on the petitioners and being And after all being agreed by these, petitioners moved an application, writ petition before the Honorable Court, and pursuant to the direction of the Honorable Justice Chaudhary, my lord, DDPNS joint obtained an joint inspections, and my lord, I am perusing the inspection report, my lord. That in the writ petition. Page my lord 147 of the writ petitions. Following irregularities, my lord, was found in 146 of the writ petitions. The issues were raised by these petitioners 1, 2, 3, 4, and 5. That is the issues. On the next page, my lord, 147. As per the inquiry report, the area of the godown of selected candidate Srimati Lakshmi Das is 440 square feet, length 25 feet, and breadth 18 feet, along with the office space having area of 263 square feet, comprising 2 chambers, other in same of the roof, which is quite suitable for using the cell counter of the shop. Thus, the fulfillment of relevant godowns criteria under government geo number such and such. The godown of Srimati Lakshmi Das is leased one of the executing the registered lease agreement for 10 years. The owner of the godown, Abul Hossain, son of late MD Ismail of village Dokhin Rampur, PS, Harishchandrapur district, Malda, submitted an undertaking dated 1st July 2023 stating that lease agreement has been made for a year of 10 years, which is duly signed between himself and Srimati Lakshmi Das. Thus, he has lawfully possession over the premises to run APS. The inquiry report also reveals that there is a covered area of backside of the godown as a waiting hall, and there is sufficient vacant space in the front of the godown and accessibility of 10 ton trucks for loading and unloading of PDS commodities. Further, for the score sheet generated in vacancy disposal module on the basis of the inspection of the godown and documents and marks given by the district level fair price of selection committee, it appears that the approved candidate has got total 74 marks as against 68 secured by the petitioners. Marks has been awarded as per findings of the inquiry into the application items and proposed godown and other criteria apportioned mainly in accordance with the government geo dated 21st August 2021, and no injustice has been done to the applications of the proposed Ms. Lakshmi Das has been selected for the license against the instant APS vacancy being eligible and suitable, and such license in terms of the relevant criteria laid down thereafter duly recommended by the district level fair price of selection committee having the highest total marks. In view of the foregoing facts and cases, I am of the opinion the petitioners is not eligible for APS license for not complying with the required criteria having an office space at least 200 square feet, and Srimati Lakshmi Das private respondent 10 has fulfilled all required criteria for being engagement of APS dealer against the instant vacancy. The allegation brought against the private respondent appears to be motivated, being far from true. Thus, my lord, the allegations, the representatives was considered, and the petitioner's allegations was not entertained by the director DDPS. And against this, my lord, petitioners come before him, my lord. And lordship, I already praise my report, my lord, evidence from report, and it is specifically transfer that the minimum criteria petitioners failed to comply the minimum criteria as per the vacancy notifications. And my lord, regarding the question of lease is concerned, regarding private respondent is concerned, registered the lease is a registered one, my lord. A registered deed is a conclusive proof, my lord. If my lord peruse the schedule of the lease 153 of the writ petitions, Taposil Chowhuddi, Jela Malda, my lord, 153, my lord, of the writ petitions.
Yes.
Taposil Chowhuddi, Jela Malda Thana, Harishchandrapur, SDS office, Tulsihata Mouja, Dokhin Rampur, jail number 110, LR Khotian 46, মোট জমির 16 আনার মোট খাজনার যোগ্য এলার দাগ নম্বর 308 বাস্তু 6 শতক 650 স্কোয়ার ফিট। তপশিলের মধ্যে 650 বর্গফুটের একটি ইটের দেওয়াল, পাকা ছাদ ও সিমেন্টের মেঝে সহ গোডাউন ঘর নির্মিত হইয়াছে, যা লম্বায় 32.5 ফিট এবং চওড়ায় 20 ফিট। হারাহারি জমা খাজনাযোগ্য দাগের চৌহদ্দি চৌহদ্দি মানে my respectful submission is the document is a registered one, and that is given by the petitioner, private respondent, and between the Abdul Hossain, and that is on the schedule. It is specifically elaborately measures that there's an 6 shatok land is theirs and 650 square feet in the godown. When the documents is registered by some the authority, that is a conclusive one. And other without any order, without any degree of the other civil code, this is not nullity. Petitioner's case this is a nullity, but this is a defective lease. My respectful submission, without any order of the civil code, he cannot say that the lease is a nullity and lease is a bad lease.
Yes.
And my lord, the order of the order of the director of DDPS, my lord, that was not even challenged by the petitioners in the writ petitions. Probably he easily accepted this report of the finding of the DDPS, my lord. He, my lord, come in the prayer, page 29, in the writ petition. In the above facts and circumstances, the petitioners most humbly praise that your lordship may graciously be pleased to pass the following orders: a writ and order of orders, directions in the nature of mandamus do issuing, commanding the respondent to forthwith deliver up and cancel the FPS dealership of the respondent number 10, the private respondent, and consider the application dated 6 November 2023 of the petitioners. A written order of direction on the nature of prohibition to issue, restraining the respondent authorities from permitting the respondent number 10 to act as a FPS dealership until disposal of the instant proceedings. A written nature of order on orders, directions, nature of certiorari to issue, commanding the respondent authorities to certify or transmit to this honorable court all records, but the order of the district DDPS has not been challenged yet, my lord. No challenge is there, my lord, apparently, my lord, in the face of record. They are accepting this report, my lord, and pursuant to their representation, the inquiry was done, and the expert committee come to a findings that private respondent comes in the better position than the petitioners, and for this regards, the previous inquiry report is not nullified by this DDPS, my lord, director DDPS. And on the basis of this inquiry report, my lord, the private respondent was given the FPS dealers. And on the basis of this, my lord, I am relying on judgment, my lord. The MM Enterprises versus the state of West Bengal, my lord.
Yes. Paragraph,
my lord. Paragraph 8, my lord. It is not for the writ court to weigh the evidence and to decide how much more marks and private respondent ought to have been given and opposed to the appellant. It is equally not for the court to see as to whether the final deed of conveyance was obtained by the appellant after last date of application. This court finds that these are subjective issues within the realm of the state, since it is quite possible for the agreement of the sale along with the possessions can be some cases to be accepted. The learned single bench has erred in entering into the disputed question of facts on selection process. It is true that the state distributions is a legacy is required for the transparent manners, fair and devoid of any arbitrariness or capriciousness. On the line of the decisions, the Supreme Court on Ramanna Setti versus International Airport Authority, that was cited by this, relied by this division bench, and important principles also laid down by the subject state distribution legacies and particularly the government tenders in the concept of the play in the joints has emerged from the decision of the Supreme Court. My lord, other Tata Cellular is also considered by this bench. The dicta laid down by the aforesaid two decisions is that while it is possible that a private respondent writ petitioners may have fulfilled all the eligible criteria, every criteria to letters of the spirit, and the applicant may have missed out of the fulfillment some of the criteria of the court should refrain from sitting in the appeal over the decision of the state. The reasons therefore is that the state is best placed to determine which content is most suitable for being the awarded distributorship. A writ court does not sit in an appeal over the administrative decisions when more than one view is possible. The court cannot and does not suitable his own views which is taken from the administrative authorities. As already stated herein, the appellant prima facie appears to have been fulfilled the eligible criteria. In such a situations, it would be grievously inappropriate for a writ court to enter reviewing inquiry to an exercise of selection process which is microscope such less seat in the appeal over the administrative authorities decision. The court notices and further error committed by the learned single, that is the findings of the division bench. And there the instant case, the court finds that some evidence on the eligibility of the applicant, there is no need in the order of any fresh tender process. My lord, in view of the above, all applications and stand disposed of. My lord, in so far my respectful considering my respectful submission before my lord, the decision is taken by an expert committee, and after that, pursuant to the direction of the Honorable Justice Chaudhary, there's an inquiry committee constituted by the expert committee inquiry, and that inquiry committee also upheld the decision of the previous inquiry committee. My lord, on the basis of this, the license was given to the private respondent. And that is all.
Yes. Reply.
Yes. First point taken by my learned friend is with respect to the list. Just to clarify, Lordship, I arrived late. The first point taken by my learned friend is with respect to the lease deed. It is a registered deed and therefore it cannot be a nullity in absence of a suit. This is the first point taken by my learned friend. Second point he has taken, he is challenging, there is no challenge to the report as submitted by my learned friend. And the third point he has taken, rather it was the first point with respect to the measurement of the shop room, that it does not fulfill the criteria. And also now he has cited a judgment, I copied that. Lordship, in the judgment, he is the submission made by my learned friend is with respect to the Honorable Court cannot sit in appeal over the decision, administrative decision taken by the authorities. Now, Lordship, may I proceed first with the initial point taken with respect to measurement of the shop room. Lordship, for this purpose, I am relying on the notification which appears at page 71, which specifies, Lordship, before that, Lordship will also take the order passed in the earlier writ petition filed by me, which recorded that my measurement of my shop room is 120 square feet. There is no dispute about the shop room being 120 square feet. Now, whether this 120 square feet shop room satisfies the criteria as per the notification. Now, Lordship will kindly take page 71 of the notification. Of the writ petition, I'm sorry. Yes. 71 of my writ petition, the notification is of 17th August 2021. In the second paragraph, and whereas the state government has decided to devise a procedure of marking system for selection as of FPS dealer, as well as to constitute a district level fair price shop selection committee in every district for the purpose of selection of FPS dealer in just and transparent manner. Thereafter, it is said that there is a square. There should be a score-based inquiry criteria, and thereafter comes the table, how the score is quantified. Now, Lordship will find the first serial number is with respect to size of go down. There is no dispute about the size of my go down, for which I am entitled to 5 points. The second point is size of attached shop room cum distribution center. Now, Lordship will find subpara C is 100 square feet to 201 square feet. I am within this limit. The minimum measurement is 100 square feet to 201 square feet. I have 120 square feet. There cannot be dispute about my shop room be not fulfilling the criteria because I fall within the required criteria as stipulated under clause 2C. Now that answers the first point taken by my learned friend. Now Lordship will consider the point taken with respect to registered. Also Lordship, in this context, my contention before your Lordship is not that I am entitled to more points. My contention before your Lordship is that the FPS dealership which has been, the license which has been granted to the private respondent, that has been wrongly done. It is not as per procedure and it is violation of the very notification on the very basis of which I am entitled to higher points. Lordship, there is a challenge to the report that was submitted. Lordship will kindly take the reliefs that I have prayed for.
No, you entitle more marks. You entitle more marks.
Yes, Lordship, I am entitled to more marks considering the criterias. First is, Lordship, the ownership. I am an owner of the entire shop.
You have given 10 marks.
Lordship, I have not been, as far as my understanding.
You have given 10 marks. See your report. You have given 10 marks. He has given 5 marks.
Lordship will kindly take the notes that has been appended to the.
You come to annexure B.
Yes, Lordship.
Of the report, page 18. Marks for domicile, you have given 10 marks.
Yes,
and he has given 5 marks. Nature of possession, you have given 10 marks. He has given 8 marks. He has given less marks than you.
এইটা কি এটা কি category এটা excess হয়েছে Lordship, I shall come back with after considering the report, Lordship.
Okay.
May I answer the other 2 queries, Lordship?
Now come on the next day.
Very well. Take your copy and that.
Please take down argument on behalf of the state respondent concludes. Let the matter appear in the list on 10th of June 2025 under the same heading. Take back or reply on behalf of the petition.
Lordship, may I take back my copy of the report have been handicapped by
last occasion.
My learned friend was not carrying the report.
There's a Xerox copy, my lord.
That is the reason why I have not been able to look into it.
Report. ঠিক আছে
হ্যাঁ
কি একটা মেনশন করলো জজ সাহেব ডেকেছেন আমাকে বলে হ্যাঁ জজ সাহেব বলে জজ সাহেব ডেকেছেন Lordship, I received a call from Mr. that Lordship has called me.
Yes, Mr. Sengupta came and said he was stuck in other matters. So he want to argue that matter again.
So Lordship has given liberty to mention. It's there in the order.
Yes.
Lordship is in the order. Lordship has given liberty to mention that they can always do.
No, Mr. Sengupta said the order cannot be signed. I want to argue that matter. That is the reason I call you. So I say Mr. Huda has to be here, otherwise I cannot, I pass the order already.
If it's taken up today at 2 p.m., my lord, I have no issues because every day I was here. Today at 2 p.m.
Today at 2 p.m. I have some other matter. actually.
I understand, but the only issue is, my lord, I have an international arbitration. I'm leaving tomorrow for Germany, my lord. I have the tickets. Tomorrow I'm leaving for Germany, my lord. I'll be there. I have a conference in Germany for 2 days. Then we'll have to move to Turkey, where the arbitration will take place.
Let me see what is the fix at 2 p.m.
Yes, if it's taken up 2 p.m., I have no issues.
Huh?
Because today, your lordship, remember that perhaps it was the 4th or 5th time that I was here, my lord.
I understand. That I said.
Yes.
That Mr. Huda was there for every day. You are not there, no person is there for you. He requested me, I'm called Mr. Huda, and then I will.
I received a call that your lordship has asked me to come, so I came, my lord. Lordship takes it after vacation in that case because the point of maintainability is always there, it's open.
No, 2 p.m. I have fixed some matters for assigned for learned advocate.
So lordship takes it up after vacation in that case. Because in hundreds of matters, your lordship has already passed orders. This is no exception. This one matter is no exception.
That cannot be like that. You one appear, he appears like that.
No, I was there. I was there every day.
And now he is not here. Today it cannot be possible. Today 2
But
p.m.
tomorrow, lordship, that's why, my lord, I have the tickets.
Also there.
I am leaving tomorrow at 9:45 in the morning, my lord.
Very well.
Takes it up after vacation in that case. In any event, I would have prayed for the same had Mr. Shwan Gupta been there.
Call next matter.
I can leave, my lord?
Yes.
Lovely.
Lord, item 18, we appear for the applicant writ petitioner. Lord, I have taken out this application, Lord, on the pretext of two notions. First of which is this writ petition was filed assailing order of grant of license to the private respondents whom I have served. Now, what has happened is during your lordship was kind enough to pass an order directing the respondents to file affidavits based on the question that I had made out a prima facie case.
Mr. Dosso, he had called.
Today 2 p.m. Learned Advocate General is there. There are some matters.
Right.
2 p.m. not possible. And tomorrow he is leaving.
Tomorrow you are leaving for?
For international arbitration in Germany.
Oh.
Let it be there. You mentioned it.
Today,
And
my lord,
Mr.
at the
Huda
time
is
of rising, is it possible?
When?
At the time of, before your lordship rises today.
Today?
Yes. Then, my lord, at the time of rising.
I have fixed.
I am ready for this.
I have fixed several matters for Advocate General today.
My lord, I am not on the way of, my lord, that at all.
Okay,
Only, my lord,
if
my lord,
Mr. Learned Advocate General is not there, then I can give you some time.
my lord, all I am asking is at 4:25 if it comments to your lordship. At 4:25.
4:25, but then you'll actually will have to sit beyond 4:30 in that case. Because I'm sure they will.
I can sit, no issue. I can sit beyond that.
Then we'll come at 4:25. Let's come at 4:25.
Okay, come on.
I'll yes.
Come on, come.
That's perfect. Obliged.
My lord, this matter, my lord, by this application, a fundamental question has been raised.
What is the application here?
This application is for an appropriate order.
Appropriate for what?
For the reason that a fundamental question which was left out to be argued and an order passed by this honorable court after admitting of this application in another matter pursuant to a same point of law. Hence, I have preferred this application since the writ petition has been admitted and the order was passed for the respondent to file an affidavit, which they have till date not done. It was an order of 25th of February 2025. Be that as it may, my lord.
You are the petitioner here.
Yes, I am the writ petitioner applicant. By this application, I am questioning a fundamental issue, which is, my lord, by way of a notification, of 2021, the marks were allotted in the present selection process, which ought to have been the notification of 2023. This is a fundamental issue which was not probably argued or not probably placed before this honorable court. And when this issue has been taken up by your lordships, I have already handed up the order that I am going to refer, by your lordships in a similarly placed issue on 25th of March. It is after the writ petition was admitted. As your lordship has taken up this issue of the notification, which notification will prevail? It was may I place this order? It starts in the first page, last paragraph. The vacancy notification itself suggests that the notification of 2023 would have been taken effect too, while tabulating or calculating the marks obtained by the candidates. But unfortunately, the respondent authorities had taken the shelter of 2021 notification and had this selection process continued and had culminated into issue where the respondent number 6 has been allotted the license. But I raised this question of a fundamental point that the authorities ought not to have relied on 2021 notification, but ought to have relied on 2023 notification. As your lordship is, my lord, have passed this order. This is my application by which I am trying to ventilate my grievance in the writ petition, which has already been admitted by your lordships.
So in the writ petition, in the pleading, you have not.
No, because
by way of application, you introduced the.
Yes, because I had got this leverage only after your lordship has taken cognizance of a similar issue, absolutely identical issue.
Very well. So this issue cannot be decided without the merit of deciding the merit of this matter.
My lord, probably in my humble understanding, this will only be the merits of the matter. If your lordship is that issue, considering this particular issue, then the all issues would be obliterated. Because the fundamental question of marking has been not done in a correct way.
Against this.
My lord, lordship, kindly, my lord, bear for a minute. My lord, your lordship takes, my lord, page 10, the grounds 1 to 10. There are 10 grounds.
There are no such grounds.
No, I say that.
My lord, he has to amend the petition. His
Without
entire case
it,
is
file
new
an
case.
application
In
for
new
appropriate
case, in application, in new case. It is never unheard. It is unheard of.
I have learned from this honorable court and many of that, my lord, a fundamental question of law.
Fundamental question of law, yes, I understand that. He may succeed in the matter, but not in the application. He has to amend the petition. Entire nature and character of the petition will be changed. And not a single ground is taken in the amended petition. Unless
I opened my case while saying this.
Unless the petition is amended, but this application cannot be entertained. But it's true.
And
default, I have not filed my opposition.
Yes. Not only opposition.
But I am in default, my affidavit in opposition is ready, this is awaiting affirmation. It will be done, but this point which has been taken in the application, this was not, there is no whisper about this, about the notification issue, 21 or 23 notification. Which
you file separate opposition or you file the joint opposition against the application as well as the entire writ?
He should either withdraw the petition or amend the petition. On this writ petition, he cannot claim.
Your lordship, I am beseeching your lordship for exercising of your lordship's inherent power, because this is a fundamental issue which was there, not placed.
Go sky.
Yes.
But
What?
always that cannot be procedure.
I am not questioning any
Yes,
factual
there is
issue
a
before this
procedure,
honorable
my lord.
court.
There is a procedure that we have learned.
If I going to hear out the entire writ petition along with your application, God forbid me to pass any order like that. You know the fate. He has raised the pertinent question.
Yes, but at the same time, my lord, I put this question to myself whether court of law, while deciding an issue,
That
can
be- okay. That would, if you want to decide the issue at the time of hearing, I will decide the issue on the hearing, not
and in this
I shall not open my mouth like that.
no, and in this way, the private respondent,
How can he make a substantive clear in the application?
and in this way, a private
Where-
respondent who does not have any right to continue in this fashion is being
Private
continued.
respondent, I don't know whether private
Yes,
respondent has
yes,
been
yes, I have
served or not.
Previously, it was served. Application affidavit service is there. Today, I have also served.
Very well. I am not hearing the application today. I am not hearing the application today. I am giving you to file opposition like that. Okay.
Only, my lord, 7 days extension. 10 days extension be given to us, my lord. It is already ready, my lord. This, whatever your lordship know the functioning of the government, my lord.
Affidavit in opposition was already
Directed.
allowed.
Yes.
Yes.
And you want
I mean,
the
before
affidavit
I
in
am yet to
opposition
file.
joint affidavit or separate affidavit in respect of three? Can three?
Now, my lord, my lord,
Can three?
my submission is, my lord, this application is not maintainable. Logically records that.
I shall record it, no issue. But whether you will use affidavit or not, that why I want to know.
So that application, yes, I'll affidavit.
That's
Yes.
why I want to know.
Yes, I shall.
Okay. Please take down. Can 3 of 2025, this is an application for appropriate order filed by the petitioner or the learned counsel for the petitioner. He submits that though submerits of the instant writ petition, though the writ petition has not, though in writ petition a specific pleading has not placed, but by virtue of application being can 3 of 2025, the merit of the entire writ petition can be disposed of, can be decided and disposed of.
And pursuant to your lordship's order in that petition, my lord.
He submits that, learned counsel for the petitioner further submits that the application being can 3 of 2025 is being supported by the decision of this court in WPA number 5844 of 2025 dated 25th of March 2025.
Grateful.
Full stop. Mr. Dotto, learned counsel, appearing on behalf of the state respondent, submits that either the petitioner shall amend the pleadings or to withdraw the instant writ petition to file afresh. But the instant writ petition cannot be disposed of on the basis of application being can 3 of 2025. The can 3 of 2025 is not at all maintained.
And the nature and character will be entirely different.
Okay. The prayer in the can 3 of application being can 3 of 2025 is totally different to the prayers of the writ petition.
Yes.
Full stop. Mr. Dotto intends to use affidavit against the can 3 of 2025. Full stop. Having heard the learned counsel for the parties, it appears to me that the application being can 3 of 2025 cannot be disposed of without touching the merit of this matter. Accordingly, the can 3 of 2025 would be disposed of along with the writ petition. The respondent authority is at liberty to file affidavit against can 3 of 2025 within 1 week after vacation. Within 1 week after vacation. Yes,
2 weeks, he says 2 weeks.
Okay, 2 weeks after vacation. The filing for affidavit in opposition against the writ petition by the respondent authority is also extended till the adjourned date. List the matter on 17th of June.
my lord, would your lordships kindly fix this matter on that day in a particular time so that the
No time, no
my
time.
lord, as a specially fixed matter, my lord, kindly, my lord,
My lord, the-
since a pertinent question probably I have tried to make out, my lord, the entire issue is
Under the heading 2 you mentioned.
my lord.
Your lordship has directed me to file affidavit of opposition to the application and writ petition both,
Application
as well as the writ
as
petition.
well as the affidavit in opposition against the writ petition. Two separate oppositions.
Two separate oppositions. Lordship, and my lord, this is subsequent application. This is not on the subsequent event. At times, but to avoid multiplicity of proceedings, there is well-known provision of law to have a
Okay, we
multiple.
come on that day today.
Very.
I'm so very grateful.
My lord,
Affidavit, my lord, affidavits of service, my lord, affidavit of
my
service.
lord, item number 19,
Etari,
period also could
18
not be heard. due to
affidavit of
proceedings.
service, my lord, kindly takes.
Honorable court asked
Take the
me to
orders.
file affidavit in service. That is, I have it is filed, and along with one ruling that for the fault of the lawyer, client should not suffer. Honorable Supreme Court, that is also given here. My lord, kindly allow me to proceed with this case and restore my original case. This is my.
You just wait. We are out of time now.
After
You are yet there in this matter.
I'm coming from Delhi, so that's why I am requesting. At 2 p.m. I will be here. At 2 a.m. 2 p.m. I will be here.
After 19?
19.
19, I have the instruction to appear on behalf of the advocate on record, who is an undergoing surgery.
You take the mic, I cannot hear you.
I am on behalf of the advocate on record of the original writ petition, by whose instruction I have understood that the settlement is withdrawn. Now he has instructed me to appear before on his behalf as he is undergoing surgery. There is some malignancy detected. He could not able to come more than 6 months. He is under the surgery now. By the Newtown Cancer Hospital, he has been treated, and he although WhatsApp me, may I hand over the type copy of his WhatsApp?
Just wait. So today what can be done?
My lord,
Today I have some fixed matter. Today I have some fixed matter at 2 p.m. Learned Advocate General has to argue on that point. After that matter, I will take up this.
My lord, may I permitted to mention on urgent determination of your lordship of 652, code number 652. My lord,
Now it is time out.
my lord,
of
it
time.
was my lord, 11:15. It was announced that matter has been assigned to your lord.
Come on after 2. Come on
My
after
lord,
2.
the urgency is that tomorrow is the next date. Extension
Come
of
on after
interim.
2. Come
Extension
after
of interim order.
Come on after 2.
My lord, if it mentioned on 2 p.m. my lord, it cannot be listed today, my lord. Extension of interim order, my lord.
No, that cannot be like that. I cannot sit entire day for you. You know.
No, at the time of rising, my lord, that's why I mentioned. If subject to your lordship correction, my lord.
Court number
652.
Okay.
Honorable Justice Sharma, my lord. It was announced at 11:15, my lord.
Okay.
Prior to your lordship, take number 2, Mr. Dilaner Advocate General is on virtual mode.
Yes.
It's from Delhi. Item number 3 is also fixed at 2 p.m. today.
You know, 3 and 7.
Yes.
These are matters in which I am to address your lordship. If your lordship may kindly take these up, on some other day, maybe tomorrow also, subject if the business of the court permits,
So item number 2 is for reply.
2 is Mr.
So,
Sahara will
I have
argue.
to address your lordship on the alternative remedy point.
Yes.
3. Your lordship, Mr. Advocate is mentioned item number 3.
Item number 3 you are mentioning.
Yes.
Yes, ma'am. Bengal agency.
Bengal agency.
Tomorrow, when you are asking for?
Any day, it can be tomorrow also, subject to the
Tomorrow
convenience
I
of
have
the
some
court.
fixed matter perhaps.
Let it appear in the same position. If it is called on
No,
our item 7 is also-
Advocate General cannot be fixed like that.
Item 7 is what we are waiting for.
Our item is 3.
Let me see. Item number 2 kota ache?
Milord, if it suits the court, it can be on Friday also, Milord, 16th.
Friday, original side matter is there at 2 p.m.
Very few matters. 2 or 1. After original side,
After original side, kindly fix, Milord.
After original side, it cannot be done. Original side will take up entire day.
I see.
what about Thursday?
Then Milord, can it be, Milord, sometimes next week, except Monday?
Thursday, there is any difficulty, madam.
Thursday সোমপাদি ঘরে 2 p.m. already fix করে রাখা রয়েছে।
Item number 3 that may be posted before vacation.
হ্যাঁ ওই নেক্সট উইকে যে কোনো দিন থার্সডে বাদ দিয়ে কাল হোক বা ফ্রাইডে তো বললো কোর্টে।
Milord, if it is not possible this week, could it be, Milord, on any of these days, 21st, 22nd, or 23rd?
What? 22nd Thursday.
ওই জন্যই বলছি যে ছুটির আগেই রাখার জন্য।
22nd 2 p.m.
Very well. Very well.
Item number 3 and 7 both.
Item number 3 and 7
Yes, Milord.
at 2 p.m.
At
Very well.
Item number 1 and
2, 3
and
3
4.
and 7.
3 will be 1. 7 will
Item number 3 and 7 দুটোই একই অর্ডার করবেন, আলাদা অর্ডার করবেন, ঠিক আছে? Let the matter appear in the list on 22nd of May at 2 p.m. as a specially fixed matter.
Very well. I'm grateful, Milord.
7 also.
And Milord, in item number 2, Mr. Shahara will be addressing your lordship, Milord.
Yes.
Because he's on reply, I don't think I have anything more to say.
Yes, let him start.
Yes. But if your lordship feels that, Milord, my assistance is required, Milord, your lordship may fix on some other day, if at all required, because he's on reply.
Okay, let him finish.
Very well.
Your lordship, a matter was mentioned with lordship had risen up for extension of interim order. Will your lordship be taking up today because the matter is on 16th before the lower court? 16th, no, day after tomorrow, your lordship. It's a determination of Justice Sharma, yes, your lordship.
It will appear tomorrow.
652 determination.
Oh, it was not listed matter.
Not listed matter.
Then
But Justice
matter
Sharma
determination. I have only listed matter determination.
only listed.
Yes. Let me take up this matter. This is specially fixed matter. After that, I will take up other matters.
কিছুক্ষণ চলবে কিছুক্ষণ চলবে এই এখন বলতিস না
What matter? Very good. Item number 22. Item number 22, you are for the petitioner. 22 and 23. Only 20. Not this week. Not this week.
After Petition.
Very well, not this week.
Learned Advocate General, your lordship knows.
Yes.
This matter raised the preliminary objection regarding maintainability of the petition. The virus of targeted public distribution system 2024 is under challenge.
Yes.
A twofold argument has been raised. Just I'm narrating. So far the maintainability point is concerned. The first point raised by Learned Advocate General.
Yes.
That association cannot file a writ petition not being aggrieved person.
Yes.
Association cannot be termed as a aggrieved person, so association has no right to file a writ petition. And the second point, so far the maintainability is concerned, his submission was that this delegated legislation, the scope of challenge such legislation is very remote. That was two submissions. Subordinate legislation. Sorry, subordinate legislation. That provision relied on some judgments, my lord. I have on last occasion placed those judgments also, and by submitting that these paragraphs are not.
And also argued regarding the Article 47.
That is on merit. That is on merit. So far the maintainability point is concerned, or specific case is that I have submitted on last occasion that this is barred by principle of res judicata. Section 11, explanation 4 says, if there is any point should have been taken in a previous proceedings between the same parties, the same has to be considered as taken the point and it has been decided. I have shown to your lordship Justice R.K. Bagh, as his lordship then was. The
previous writ petition was filed by the state on the other occasion.
Same association was the writ petitioner, petition number 2. Same issue was there.
Yes.
Virus of 2013 control order was under challenge, but those 2 points have not been raised. So, in terms of section 11 of the Civil Procedure Code, explanation 4, it directly hits the principle of res judicata.
Constructive res judicata.
Constructive res judicata, because these points should have been taken, and if not, since has not been taken, they cannot be taken on the subsequent proceedings. I have also relied on one judgment, 2010, volume 10 Supreme Court cases, page 141.
Yes.
Alka Gupta versus Narendra Gupta, same issue has been considered, para 23-24. I have placed before your lordship. Now, some judgment has also been placed before lordship. I sought to distinguish the same. But I must say, my lord, no Supreme Court judgment has been placed so far the maintainability point is concerned. Only some High Court judgment has been placed. Now that next course of submission, so far as the merit is concerned, although my respectful submission before your lordship, so far maintainability is concerned, there is no question to consider the same. Now the merit my learned friend has submitted before lordship, placing some constitutional provision. First, my lord, Article 39B. You have to kindly take. I'm placing before lordship. I have flap. Your lordship need not go through your lordship book because I can hand over with flap.
Yes.
May I hand over?
I have the book.
Because I have given the flaps, that will be easier for your lordship. Yes. The pagination will also be tallied. But kindly come to Article 39B. That has been placed before your lordship by my learned friend.
Yes.
May I read my 39B? Certain principles of policy to be followed by the state shall, in particular, direct its policy towards securing that the ownership and control of the materials resources of the community are so distributed to be best subserve the common good. So, according to London Advocate General, that state is the best authority to decide in which manner
Yes.
Material shall be supplied. They are the best authority. Now the next provision has been placed before Lordship, Article 47.
Yes.
I'm reading 47. Duty of the state to raise the level of nutrition and standard of the living and improve the public health. The state shall regard to the rising of the level of nutrition and standard of living of its people and the improvement of public health as among its primary duties, and in particular the state shall endeavor to bring about prohibition of the consumption except of the medical purpose or intoxicating drinks and of drugs which are injurious to the health. But this provision has been relied on. Just I am showing your Lordship the next provision which has been relied on, Article 246 2.
Yes.
Article 246, subclause 2, I am reading, my lord. 246, subject matter of laws made by Parliament and by the legislature of states. Notwithstanding anything in clause 2 and 3, Parliament has excluded the power up to make law with respect to any of the matter enumerated in list 1 in the 7th schedule, then my lord 2. Notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of the state also have the power. Then 3, subject to clause 1 and 2, the legislature of any state has exclusive power to make laws for such states or any part thereof with respect to any of the matters so and so. But relying on this, the submission which has been advanced before your lordship, before that your lordship also which has been relied, my lord, kindly come to schedule 7, list 3, entry 33.
That is the concurrent list.
Concurrent list. So relying on these provisions, the argument which has been advanced before your lordship, that national food security has been framed under Article 47 of the Constitution of India.
Yes.
Article 47, kindly, once again, if your lordship, kindly come to Article 47. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. Relying on these provisions, my lord, it is the submission on behalf of the state that national food security has been framed under Article 47. But I am not disputing the same also. I am also not disputing the same. The next submission, following the above submission, which has been advanced before lordship, that the public control order has been framed under the Essential Commodities Act.
Yes.
Two submissions have been raised. So far, the national food security is concerned. That is under Article 47 of the Constitution of India, framed under Schedule 7, List 3, concurrent list, entry number 33. And the second submission was control order has been framed under the Essential Commodities Act.
And Essential Commodities Act is the source of Article 39B.
39B, absolutely.
This is the submission.
Yes. So, state has enough power to proceed with the matter so far essential commodities are concerned. They can frame rule without taking any help of any central control order. And at best, they have the right to do so under GSR 800. That was the submission as I understood. I have lastly submitted with your lordship on last occasion that prior to 2003 control order, framed in pursuance of Section 3 of the Essential Commodities Act, read with Central Control Order 2001, there was no licensing system. Dealers and distributors were being governed and controlled in terms of an agreement being executed by the licensing authority and the dealer concerned or the distributor concerned. There was no licensing system. I'm just handing over your lordship two facts. First one is, my lord, in respect of the distributor, and the second fact is in respect of the dealer. This was the position at law prior to coming into force 2003 control order. Entire distributor and dealership business was being governed and controlled under this agreement. How the license will be granted, which manner punishment should be imposed, everything is there. But there was no license. I have also submitted before your lordship, my lord, prior to 2001, there was no central control order. Now I shall place before your lordship one after another. The 2001 control order first. Possibly, my lord, this copy has already handed over. Again, I am handing over. But this is the first central control order, monitoring and controlling entire ration system. This is the public distribution system. But this is dated 31st of August 2001. Thank you. Last time. এটার উপরে
Yes.
But this is dated 31st August 2001. On last occasion, I have submitted before your lordship by placing 800 GSR. That GSR 800 means only in respect of foodstuffs. This is the first time central government framed a rule for monitoring, controlling public distribution system. That is the ration system. Kindly read, my lord, two, three paragraphs. Whereas the central government is of the opinion that it is necessary and expedient so to do for maintaining supplies and securing availability and distribution of essential commodities under the public distribution system. Kindly take note of public distribution system. Now, therefore, in exercise of the power conferred by Section 3 of the Essential Commodities Act 1955, the central government hereby makes the following order, namely, this order may be called the Public Distribution System Control Order 2001. Kindly pausing for a moment. I have submitted before your lordship that the source of power of the central government to monitor, control essential commodities is Section 3 of the Essential Commodities Act. I have also submitted before your lordship
Yes.
So, my lord, this control order has been enacted by the central government in exercise of the power under Section 3 of the Essential Commodities. That has been recorded. I have also submitted before your lordship that the Section 5 is the power of the central government to delegate the power to any state government to frame rule under concurrent list by issuing notified order fixing therein the terms and conditions. But this is the said order. This order empowers the central state governments to frame rule or make any control order in exercise of the power under Section 3 of the Essential Commodities Act.
Yes.
So this is the source of power of the state government to monitor, control rationing system of the respective states by issuing an order. But that should be consistent with the terms and conditions of this order, because Section 5 says notified order fixing the terms and conditions. So it should be consistent with the control order 2001, whatever may control order being framed by the state government. Well, kindly come to annexure 1 section. I shall show to your lordship. Page 36. There is a ink mark. If your lordship kindly take, don't ignore it. Ink mark 36. There's a pagination by ink. Page 36. Have you lordship got my lord?
Yes.
My lord, kindly see section 7. Not section, my lord. Clause 7. Licensing. The procedure for issue of license or authorization to the fair price shop for the distribution of essential commodities under public distribution system and duties responsibility of the fair price shop owner shall be as per paragraph 5 of the annex to this order. Now kindly come to the annex to this order. Kindly come to page 40, ink mark. Have a look, got my lord?
Yes.
Licensing. State government shall issue an order under section 3 of the Act. Kindly take note of. For regulating the sale and distribution of the essential commodities. The license to the fair price shop owner shall be issued under the said order and shall lay down the duties and responsibilities of the fair price shop owners. The responsibilities and duties of fair price shop owners shall be included entirely. So, which manner dealers shall be controlled and monitored by the state, the same shall be recorded in an order to be issued by the state government in exercise of the power under section 3 of the Essential Commodities Act. Read with this order 2001. The submission on behalf of the state that the section 3 independently this power has been given. There is no need to any control order by the central government, even we have recorded the same. So, source of power of the state government is not section 3, not section 5 even, unless there is an order notified by the central government fixing the terms and conditions. This manner, you have to frame a rule. For granting license, monitoring business, suspending, termination, everything is there. If you have to go through these subsequent paragraphs, everything is there. Now, my lord, following the same, 2003 control order has been framed. But there are two control orders. One I have submitted before lordship under 2003 control order. One is my lord urban control order and another is rural. Same condition, terms and condition. Because for rationing areas, that is my lord urban areas, kindly see my lord. I am reading second paragraph. Now therefore, kindly take note of. Yes. Now therefore, in exercise of the power conferred by section 3 of the Essential Commodities Act 1955, read with the Government of India Ministry of Affairs Science of Public Distribution Order GSR 630 31st August 2001. First page, second line, second paragraph. Now therefore, your lordship may read first paragraph also. Now therefore, in exercise of the power. So, my lord, this control order of 2003 has been framed by the state government as delegate in exercise of the power under section 3, read with 2001 central control order.
Yes.
So, only section 3 does not empower the state government to frame any law controlling and monitoring rationing system or the public distribution system. Because section 3 empowers only after section 5 delegates the power. At delegation, this is the procedure, notified order.
Yes.
But kindly come to the penalty provision. Just licensing is also there at page, my lord. Clause 26, page 66. There is also a typing mark. It will also kindly come to page 66. The pagination is there. Have a lordship. Kindly see clause 26 in 2013 control order.
Yes.
Or to suspend or cancel license. Kindly see, my lord, show cause procedure is there, reply is there, opportunity of hearing is there. Only then punishment can be imposed. if a licensee or his agent or servant or any other person acting on his behalf contravene any of the provisions of this order or any of the regulations made thereunder, or any of the condition of this license, the director shall issue a notice to the licensee. This urban control order. So director is the authority. The director may forthwith temporarily suspend the license if the opinion of the director and so and so. The director may, by order, after giving the license an opportunity of stating his case. So there is a procedure for issuance of show cause, asking the concerned dealer or the distributor to submit your reply. Then on dissatisfaction, opportunity of hearing, then penalty can be imposed. Why I am showing to your lordship, I have already submitted 220-24 control order. There is no such show cause proceedings. Now your lordship, kindly take note. This order has been repealed, and this is the rural control order I have submitted before your lordship. Your lordship will also find penalty provision at page 29. 2003 and 2013, two separate procedure, one for urban areas and one for rural areas. Urban control order and rural control order. So
Yes.
far this is concerned, kindly see, my lord, there is also a penalty provision at page 39. Flap, I have given the flap. So all together in all control orders, state government has notified in exercise of the power under section 3 read with central control order and inconsistent with the terms and condition of the central control order. Kindly see penalty provision. Show cause, reply, opportunity of hearing, then only punishment.
Yes. In central control order, there is also some such.
All same provisions, same provisions. Now, your lordship, 2013 control order came into force.
Yes.
By repealing 2003 control order. Your lordship will find in the same manner in exercise of the power under section 3, read with central control order 2001. Kindly take the book, my lord, possibly. So far, the rural control order is concerned at page 1.7. Urban. Page 1.7.
Urban public distribution system.
This order may be called the West Bengal public distribution, not urban. Page 1.7.
1.7. Yes.
Have a lordship got pen? And urban is at page 2.7. 2.7 is the urban and 1.7 is the rural. After essential commodities, that 1.7 bottom. Pagination is that bottom, 1.7. Yes. Kindly read the top. Whereas the governor is of the opinion that it is necessary and expedient to so to maintaining supplies and securing availability and distribution of essential commodities under public distribution system. Top. Essential commodities, last line of the first paragraph, under the public distribution system. And then, now, therefore, in exercise of the power conferred by section 3 of the Essential Commodities Act, read with the Government of India, Ministry of Consumer Affairs, Food and Public Distribution, GSR number so and so, dated 31st August 2001, the governor is pleased to hereby make the following order, namely, this order may be called West Bengal Public Distribution System Maintenance and Control 2030. So again, in exercise of the power under section 3, read with Central Control Order 2001. Licensing provision is there. If you lordship kindly come, the penal provision also. Penal provision. 24 clause 24 1.24 page, same provision. Twenty-four 1.
Yes.
If a licensee or his her agent or any other person acting officer behalf contravenes any of the provisions of this order or any of the regulations made thereunder, or any of the conditions of his license or any discrepancy of stocks or any device, the subdivisional controller food and supply shall issue a notice to the concerned dealer asking for explanation. Show cause, reply, second paragraph. The licensing authority, after giving the licensing an opportunity of being heard. So these are the principle of natural justice. First, show cause, reply, then opportunity of hearing. On dissatisfaction or insatisfaction, drop the proceedings. Now, Your Lordship, kindly come to the urban control order, page 2.7. Repealing 2003 control order, these two control order has been framed. One meant for rural areas of state and another for urban areas of state. Page 2.7. Same language, verbatim to the rural control order. First paragraph and second paragraph in exercise of the power. Same. This order may be called the West Bengal Urban Public Distribution System. Then kindly come to the penal provision. Kindly come to page 2.31. The same provision, show cause, reply, opportunity of hearing, then only penal action, clause 29, 2.31 page.
Yes.
Shall issue a notice, kindly see, last line, page paragraph 29, to the licensee for showing cause of such contravention. Then opportunity of hearing in the next page. Second paragraph, page 2.32, the licensing authority, after giving the license an opportunity of being heard. So up to 2013, in both the control orders, I want to show before Your Lordship, not only exercising power under section 3, all these four control orders, section 3, read with control central control order. Punishment portion, show cause, reply, hearing, then principle of natural justice. Now, Your Lordship, kindly come to page 42 of my writ petition, 2015 control order. Page 42.
Yes.
Just I am reading 20th March 2015. Whereas the central government is of the opinion that it is necessary and expedient to do for maintaining supplies and securing availability and distribution of essential commodities, namely food grains, under the targeted public distribution system. I have submitted time and again before Your Lordship. This targeted public distribution system came into force only from National Food Security Act 2013, targeting a section of the people or the society. A scheme has been framed after 65 years of the independent opera country. I shall place before Your Lordship the preface of the 2013 Central National Food Security Act. It supersedes 2001 control order, second paragraph. So, today for implementation of National Food Security Act, only control order is 2015 control order.
Okay.
The submission on behalf of the state that there is no need to take any help from any central control order is absurd proposition of law. Section 3 directly never empowers the state government to frame any rule controlling and maintaining essential commodities or public distribution system. You have to take help of Section 5, particularly control order to be framed by the central government, delegating the power to the states. Now, Your Lordship, kindly take up the 2024 control order. At page, my lord, 24. National Food Security.
National Food Security.
No, I'm sorry, I'm placing the order. Sorry, my lord. TPDS State Control Order 76. Sorry, my lord. I'm extremely sorry. 76. You have followed. You are maintaining the same. From the part it is submitting, there is no need to take any help. Kindly take note of, my lord, page 76. Whereas the Government of India, Ministry of Permanent so published distribution department so in exercise of the power conferred by Section 3 of the Essential Commodities Act, Central Act 2000 has issued Targeted Public Distribution System Controller 2015. Kindly take note of GSR so. And whereas pursuant to the clause for so of the Targeted Public Distribution System Controller 2015, the state government is empowered to issue order under Section 3. It is your recording that state government have been empowered by virtue of 2015 Central Control Order. That is TPDS Control Order 2015. It is your statement. Under Section 3 of the Essential Commodities Act for regulating ration card, licensing, regulating for fair price shop, concern of a fair price shop, monitoring, controlling, so and so, penalty, power, suspension, so and so, so and so. So entire power has been vested upon you, or source of power is 2015 Central Targeted Public Distribution System Control Order. You have framed the rule also following the same. Now, therefore, the governor is exercising the power conferred by Section 3 of the Section 5 of the Essential Commodities Act. Kindly take note of. Read with the Government of India, Ministry of Government so and so, Controller Department Food and Supplies, dated 20th March 2015. Please to hereby frame the rule. This order may be called the West Bengal Targeted Public Distribution System Maintenance and Control Order 2024. So I have shown to your lordship from very inception of formulation of control order by the central government. Under Section 5 of the Essential Commodities Act, states are time to time framing rule control orders. In exercise of the power, Section 3, read with those central control orders 2003, 2013, 2024 also. The submission which has been advanced before your lordship, this is contrary to their own act. Contrary to their own control orders, not only one, 5 control orders. Urban, Rural 2003, Urban, Rural 2013, and this is a composite for Urban and Rural 2024.
Yes.
Source is Section 3, submission on behalf of the state, that NAPSA under Article 47. So, there is no need to take any help of the National Food Security Act or 2015 control order. It's absurd proposition of law. The source of power to frame, rule, monitoring, controlling public distribution in the state is Central Control Order 2015. Read with Section 3 of the Essential Commodities Act. But I have sought to distinguish all the judgments which has been relied on behalf of Advocate General. Now I shall rely only one judgment, although my specific case is that point of maintainability is not left open for the state to raise any subsequent suits, that is the present repetition, when you have not taken this plea in the previous challenge when virus of 2013 control order was under challenge by the same self-writ petitioners, by the secretary and the association. The first judgment actually, my lord, has been fallen from your lordship on the first day when Mr. Learned Advocate General was placing his case. My lord, this is Paschim Bongo, Bhumijibi, Kishok, Shomiti and others. My lord, kindly see that, take note of the date of judgment, 26th of July 1996. 26th July 1996, which will appear from page 213 top. But I have given the flap. If you will kindly come to paragraph 165, 166, 168. At page 266, I have given the flap possibly, madam. Have you got madam? Page 1, paragraph 165. I have given a flap possibly, madam. Not there, you know.
Yes.
Well, I'm reading paragraph 165. Factor point. So far as the submission of Mr. Gupta to the effect that the petitioners have no locus standi is concerned, the same is not necessary to be considered in details. It is not disputed at the bar that hundreds, if not thousands, of writ applications had been filed in this court questioning virus of this act. Even on the appellate side, there are various cases which have to be considered by us. The question which have been raised in this case arise in one form or the other in the said application. Furthermore, the learned trial judge has passed a judgment on merit after hearing the counsel for both the parties. The learned trial judge has also rejected the contention of Mr. Gupta to the effect that petitioners have no locus standi to question the virus of the said act. We agree with the reasoning of the learned trial judge and we therefore reject the contention. It is, however, relevant to notice that in Akhil Bharatiya so. Then paragraph 166. Akhil Bharatiya Karmachari Sangha has been dealt with, then paragraph 166. In DS Nakra's case, it has been held by the Supreme Court that a society on behalf of class of persons prejudiced by a common grievance can maintain the writ application. In this case, also the petitioners are representing to the state their common grievance. Then paragraph 168. It also appears that even the matter was heard on merit for a number of days in respect of so-and-so, emit number so-and-so, before a bench presided over by A.M. Bhatta so-and-so, the justice of this court, on the application for amendment and possible on merit on several locations so-and-so. We will, in our opinion, trapezoidal justice the writ so-and-so, so the writ is maintainable. But two judgment has been relied on. One DS Nakra and another is, my lord, Bharatiya Shoshit Karmachari Sangha. Again, I am placing before your lordship the date of judgment, very important. Kindly see, my lord, this is a judgment of dated 26th of July 1996. Learned Advocate General has relied on three judgments. One is 1977 CHN, one is 1993 2 CLJ, and only one judgment of Learned Single Judge of Madras High Court 2011. So far 1977, 1993 is concerned, both are prior to this judgment. The judgment which has been relied on by in this case, I am relying also those judgments, Akhil Bharatiya Shoshit Karmachari Sangha. Well, this has been reported. I have given the flap also. Yeah, 1981 Supreme Court, page 298. 1981 1981 1 SCC page 246 লিখে দেন 181 1 SCC page 246 मतलब paragraph 62 at page 281 just one paragraph I shall read. Paragraph 62 at page 281. May I read my? A technical point is taken in the counter affidavit that petitioner is an unrecognized association. This is unrecognized. So far we are concerned, we are recognized, registered. And that therefore the petitioner to that extent is not sustainable. It has to be overruled. Whether the petitioners belong to a recognized union or not, the fact remains that a large body of persons with a common grievance exists and they have approached this court under Article 32. Our current personal jurisprudence is not to the individual issue Anglo-Indian mode. It is also broad-based and people-oriented and investing access to justice through class actions, public interest litigations and representative proceedings. Indeed, little Indian, kindly take note of, indeed, little Indian in large numbers seeking remedies in courts through collective proceedings instead of piecing driven to an expensive parliamentary litigation is an affirmation of participation in the justice in our democracy. We have no hesitation in holding that the narrow concept of cause of action and person aggrieved and individual litigation is becoming absent in some jurisdiction. It must fairly be stated that the learned Attorney General has taken no objection to non-recognized association maintaining the writ petition. This is a non-recognized. We are recognized, registered association. There is no dispute about the same. Every time meeting is being held only with our association by the food officials, even by the principal secretary. This is the only association registered, recognized. This is Akhil Bharatiya. Now, Your Lordship, kindly see the Supreme Court judgment on the same point. D.S. Nakra, reported in 1983 Supreme Court, page 130, just one paragraph, paragraph 64 at page 149. I have given the flap also. This is D.S. Nakra. My Lord, kindly see 5 judges bench. I think so. My Lord, kindly see first page. Special bench, 5 judges bench of Supreme Court. First.
Yes.
Yes. Then Your Lordship, kindly come to paragraph. I have given the flap. Para 64 at page 140.
Yes.
Paragraph 149. Sorry. Paragraph 1. Yes, page 149. I am just reading. Paragraph 64. May I read, my Lord? Locus standi, have a lot of court. Locus standi of third petitioner was questioned. Petition number 3 is a society registered under the Societies Registration Act 1860. It is non-political, non-profitable voluntary organization. Its members consist of public-spirited citizens who have taken up the cause of ventilation, litigating public problems. This society received a large number of representation from old pensioners, individuals unable to undertake the journey through labyrinths of legal jurisprudence process, costly and protected, and therefore approached petition number 3, which espoused their cause, object for which the third petitioner society was formed, where the question were not questioned. The majority decision of this court in so and so rules that a member of the public having sufficient interest can maintain an action for judicial redress or for public injury arising from breach of public duty or from violation of Act for so and so as inserted by the Prevention of Food Alteration Act so and so for so and so with respect of prosecution so and so and read with section so and so from so and so such offer so and so to the law then enforce the act as amended by Prevention of Alteration Act so that the West Bengal administrations are punishable with so and so for the reason therefore to the court of the citizens. So what D.S. Nakra has been relied on Bhumijibi Kishijibi Samati and the previous judgment which I have also shown. Well, this is a Supreme Court judgment. Again, I am repeating, learned Advocate General failed to place any Supreme Court judgment so far this maintainability of writ petition by the association is concerned. Now, one judgment of our High Court of a coordinate bench I shall place before your Lordship. The submission which has been advanced before your Lordship that Section 3 straightway empowers the state government to frame rule. There is no necessity to frame rule taking advantage of any central control order. Although from all the control orders I have placed before your Lordship that state himself has done so. Now, your Lordship, this point has been considered by a coordinate bench in a previous matter, which has not been appealed by the state. But kindly come to page 10 of the judgment. This is a series of matter heard by Justice Pottonayak, which is under appeal and stay has been granted. But so far this point is concerned, paragraph 8, the learned single judge coordinate bench held in our favor. Page 10, paragraph 8. I am reading, my lord. 3 issues have been framed. Out of that, 2 issues in our favor. But so far the second issue is concerned, that was gone against us. Accordingly, my lord, petition has been dismissed. We are only concerned, so far this matter is concerned, issue number 1, whether the state controller 2003 is a delegated legislation or an independent delegated legislation. The same argument has been advanced. Kindly come to the next page. Query number 1, whether the state control order 2013,
You are reading page?
page my lord 10,
Page 10.
paragraph 8.
Yes.
On such submission, advance the bar, following questions need to be examined and answered. But 3 issues has been framed. 1, 2, 3. In that case, my lord, issue number 1 and 3 goes in our favor, and issue number 2 goes against us, and ultimately petition dismissed. But we are concerned about issue number 1, whether the state controller 2013 is a delegated legislation or an independent delegated legislation. Kindly turn the page. Query number 1, whether the state control order 2013 is a delegated legislation or an independent delegated legislation. In order to find an answer to the query, as aforesaid, it would profitable to produce the relevant provisions of section 3(1) and section 5 of the Essential Commodities Act. But that has been quoted then. Upon bare reading of the aforesaid provisions, it manifests that the section 3 of the Act 1955 empowers the central government to make orders for regulating or prohibiting the production, supply and distribution thereof, and trade commerce therein wherein finally necessary or expedient so to do for maintaining and increasing supplies of any essential commodity or for securing their equitable distribution and availability at the fair price. Section 5B of the Act of 1955 empowers the central government by notified order to delegate such power to make orders or issue notification under section 3 be exercisable also by such state government or such officer or such authority subordinate to a state government in relation to such matters and subject to such conditions, if any, as may be specified in the direction. Thus, there cannot be any quarrel that the power of central government under section 3 of the Act is exercisable by the state government upon order of delegation of central government under section 5 of the Act. Mr. Swanso, learned junior standing counsel for state correspondence, now he is my senior standing counsel, tried to impress upon the court that the government of India, in exercise the power conferred upon it under section 5 of the Act of 1955, issued notification being number GSR so-and-so, declaring that the power conferred upon it under section so-and-so in relation to footstep would be exercisable also by the state government, and thus control order, be it central control order or TPDS control order 2015 issued by the government of India or control order 2000 issued by the government of West Bengal, are independent delegated legislation made by two separate governments in exercise of the power conferred under section 3 of the Act 1950. In order to appreciate the aforesaid argument advanced on behalf of the state respondents, it would be appropriate to reproduce the relevant portion of the West Bengal Public Distribution System Maintenance Controller 2013, the same language in 2024, paragraph 13. Upon bare reading of the aforesaid, it goes without saying that the State Controller 2013 has been issued in exercise of power conferred by section 3 of the Essential Commodities Act 1955, read with order number GSR so-and-so dated 31st August 2001, issued by the Government of India, Ministry of Consumer Affairs, Food and Public Distribution, Department of Food and Public Distribution. Needless to mention that the State Controller 2013 has been issued pursuant to the delegation given by the central government under the Central Controller 2001. Thus, there cannot be any quarrel that the State Controller 2013 issued by the State of West Bengal has its genesis in section 3 of the Essential Commodities Act and Controller 2001 of the Government of India. It is relevant to note that State Controller 2013 never records that it has been issued in exercise of the power conferred by its notification GS so-and-so 78. Therefore, the argument that the State Controller 2013 issued by the Government of West Bengal is independent delegated legislation is not tenable and acceptable. But no appeal has been preferred against that order by the state. State has accepted this position. So far the judgment of the coordinate bench, this issue is concerned.
Yes.
Well, now I shall show from my repetition why I am saying that 2024 Targeted Public Distribution System Control Order framed by the West Bengal, State of West Bengal, is inconsistent with 2015 Control Order, and whether the Provisions of this control order are arbitrary, unreasonable, unjust, unfair, and without any logic. Your Lordship, kindly take up my writ petition first. It's 76 first. It starts from State Control Order 76, 75, 76. I have shown to your Lordship, I need not go through the same. Kindly turn to page 87. 78. Kindly turn to my page 78. Kindly, these are the definition clause. Kindly come to my lord 2J. But 2JDD. Have you lordship got my lord? From bottom second paragraph or third paragraph. 2JDD. Page 78. Definition clause.
Yes.
DPTS control order means this is state control order. The targeted public distribution system control 2015, published in the Gazette of India externally under GSR so-and-so dated 2015. So they are also saying that state control order means targeted public distribution system control 2015. Next. Words and expression kindly see approach to words and expressions are not defined in any control order. So act are the rules framed by the under the TPDS control order so and so. That is also there. And act. Act means, my lord, National Food Security Act. Now your lordship kindly come to page 81. '87, 82. Page 87. ঠিকঠাক বলছো তো? Clause 20. কোথায়? Kindly come to clause 20 at page 87. Provision for resignation by a dealer. A dealer may resign by giving a notice under the hand addressed in the licensing authority, under his hand addressed to the licensing authority, but he shall continue to run the fair price shop until his resignation is accepted by the licensing authority. Can you take note of? I am a 8 years old dealer, got admitted in hospital for last 6 months. I submitted an application for resignation. It is the whim's choice of the state government when they will accept. Only that day I shall be released. I may submit my resignation letter 2 years back. They may kept in pending. No time, nothing is mentioned. According to the whims and choice, they will accept it. Kindly take other way also, my lord. I am a dealer. I participated in a selection process for service. I applied for, I have been selected. There is no bar. But at the time of joining, I have to submit that I am not any business. I applied for 2 months time has been given by the employer. They kept it pending for 1 year. I will not get the job. An unemployed youth running dealership business with the hope, education, everything. So it is the whims and choice of the state government when they will accept the resignation letter. Now, your lordship, kindly come to page 97. Thank you. Chapter 9. Chapter 6.
Yes.
Kindly come to chapter 6, clause 39. Provision for grant of license on happening of certain contingencies. engagement of dealer or distributor on the death or medical communication license during validity of a license. In case of a death or any existing license, any of the eligible family member who is wholly dependent on the disease so-and-so, state so-and-so, 90 days so-and-so, your lordship need not go through the entire thing. Kindly come to my lord, clause 4, after 1 to proviso. Clause 4, Roman 1 to then provided. Provided that while forwarding the case of engagement of distributor or dealer on medical ground, the licensing authority shall cause to examine the medical prescription and or medical certificate issued by a government doctor. My treatment may be in a reputed nursing home and certificate with me that I am incapacitated, but that will not suffice. I have to bring a certificate from the health center or medical officer of the state government. I had numbers of certificates from reputed nursing homes like Bellevue, Amri, but that will not suffice. I have to bought a license, certificate from a government doctor. Even it is acceptable from the primary health center. Unless I produce this certificate, I will not be allowed to make application on medical count to transfer my license. Then my lord, kindly come to 98. Next page. But clause 40. Provisions relating to licensing of partnership in certain contingency. In case of partnership from on occurrence of death or resignation or incapacitation on medical ground of the partners, following procedure shall be followed. Kindly take my lord C. First, 40C. The surviving partner may apply within 5 days from the date of occurrence of such events in prescribed form to the licensing authority for grant of license to a reconstitution firm. I'm not pausing for a moment. Two partners, two brothers are the partners. But elder brother died. He has two sons, unemployed. Unless the existing partner, that's the uncle, made an application for reconstitution of the farm, these two sons of the elder brother has no right to apply for. The legal heirs of the deceased dealer or the family members have no right to make an application for incorporation of their names in the partnership, dealership or distributorship business for reconstitution of the firm. Only existing partner empowers to make an application. If you also kindly take in this manner that the brother, who is the existing partner.
No, is there any provision for legal heirs of the deceased partner? There is provisions.
My lord, I'm coming, I'm sure.
Yes.
So, but this part is concerned, your lordship has heard one matter, possibly hearing is going on.
Yes.
What happened, my lord? Just first, your lordship kindly take C. Surviving partner can make only application. A scenario I am placing before your lordship. The surviving partner thought it fit not to make any application. He will leave the business. He has enough resource, he will not continue the business. The person who died, that's the elder brother. He has no source of income. Only source of income was from this business. But his sons or daughters or wife cannot apply for the license. License will be cancelled and vacancy will be declared. If the existing partner thought it fit not to continue the business, ultimately license will be cancelled. Now, your lordship kindly see D. The reconstitution of firm, my lord, your lordship has sent, my lord, there is a
Yes.
provision. Which provision, my lord? I'm just asking myself. Your lordship just followed from your lordship that there is a provision, the existing or the.
Is there any provisions for legal heirs of the deceased partner to incorporate in the business?
Yes, yes, that's I'm reading. Kindly read. The D. The surviving partner may apply within 40 days from the date of recognition of such events in the prescribed form to the licensing authority for grant of license to the reconstituted form.
Yes.
The reconstitution shall be made with the existing partner along with the
Legal heirs.
no, family members, sorry, family members of the deceased.
Members of
This is
deceased.
very clear.
This is
It
part.
will more clear in D. The reconstitution of firm shall be in accordance with the eligibility criteria for grant of new license under this order, notwithstanding anything contrary to the content in the partnership deed. It says, my lord, reconstitution shall be done in accordance with the provisions laid down for grant of new license. What new license grant procedure laid down? Kindly come to page 80.
That means eligible criteria would be.
Yes, which suggests not more than 45 years. So, two partners, senior partners died at the age of 50. His wife, whose age is 46 years, he will not be allowed to be a partner of his husband's partnership, dealership or distributorship. The procedure laid down for grant of license is to be followed in case of death of a partner.
All eligible criteria would be
By
same.
law. So one of the eligibility criteria, not more than 45 years. A person died at the age of 48, leaving behind his widow 46 years. She will not be eligible, having no source of income. But these are all discrepancies, unreasonable, unfair, illogical, having no logic behind it. Next. 102. The main thrust of my submission. There are other provisions also. I am not going elaborately so far these conditions are concerned. Kindly come to my page 102. This is chapter 9, which had been stated by your lordship and ultimately quashed on the single ground that point of maintainability has not been considered. I shall show to your lordship that judgment also of the division bench. Penalty. Save as otherwise provided herein below, whenever contravenes the provisions of this order, shall be liable to be permissible so and so under section 6. Penal action against a dealer, contravention if a dealer is authorized representative of any other so and so. These are the penal provisions. Then, my lord, kindly come to the after Roman 12. The licensing authority may, after giving an opportunity of being heard, kindly take note of. The dealer and for the reasons to the recorded in writing impose penalty according to the gravity of the offense on so and so. No show cause. No reply. Just I am telling to your lordship, even it not says that the notice inviting you to come before the dealer, come before the office, there is no mentioning that reason should be disclosed. These are the charge. So 2-line letter, tomorrow there will be a hearing or day after tomorrow, you please come to the office chamber. I shall go there. I have to sign put my endorsement. I have to put my signature in the attendance register. Nothing may be told to me. Nothing may be disclosed to me. After conclusion 5 minutes, the controller may say, please, hearing has been concluded, you may go. On the very next morning, I may found that my license has been terminated. The provision says only opportunity of hearing. No video recording, nothing. A letter, please come to my chamber on that day at 12 p.m. At 12 p.m. on the particular day, I shall go to the venue. Nothing will be disclosed me what is the charge against me. After endorsing my signature in the attendance register, I may be called for hearing has been concluded. I don't know what is the charge, who has brought it, what is the complaint against me. On the next day, I may get an order of termination saying these are the charges, and it has been proved. I have to prefer an appeal, statutory appeal. There is no provision for stay. I have to prefer second appeal against the first appellate authority. There is no provision for stay. Your Lordship knows also time-bound program has been given. At least it takes 1 to 2 years. A third-party right will be arised. He will enjoy my dealership. After conclusion of the entire proceedings up to second appellate authority, when I will come, I will find there is a person who is running my dealership business. But this is principle of natural justice. Any provision of any law says that penalty, capital punishments can be imposed only after providing opportunity of hearing without intimating you what is the charge framed against you. I have not crossed over any of such provision in any service matter or any matter, any contract, any tender. I am running business for last 30 years with full reputation, not a single show cause. One fine morning, please come to my chamber. One line letter, participation, endorsing signature in the attendance register. Very next day, termination of license or true course fine. When I will come before the court, the state will submit, just first exhaust your remedy in the statutory remedy. I have to file first appeal. Again, I shall come before the court, go and exhaust your remedies. Second appeal. In the meantime, vacancy, if I don't get any interim order, vacancy, because there is no provision for any stay, either by the first appellate authority or by the second appellate authority. Is it, my lord, permissible? Is it not arbitrary? Is it not unreasonable? Is it not unjust? Is it not unfair? Having any logic behind it? In 2003 control order, I have shown in both the control orders, show cause proceedings, hearing, satisfaction, reply, 2013, show cause, reply, opportunity of hearing, reasoned order. This is the first time it has been incorporated, rather deleted, excluded, which prompted your lordship to pass an interim order, staying the entire chapter 9.
Yes.
Then more dangerous thing as a page 108. Kindly turn to page 108. On appeal and review, chapter 12. 57 deals with the appeal, a licensee who is active by an order of the licensing authority. First under chapter 9 may within 30 days from the date of receipt of such order prefer an appeal to the first appellate authority. Kindly take note. Then clause 2, second appeal. Then kindly come to clause 4. Subclause 4 of clause 57.
Yes.
While disposing of the appeal, the first appellate authority or the second appellate authority, as the case may be, has the power to, clause B, enhance or reduce or vary the penalties imposed upon the licensee. No show cause, no reply, termination, appeal, termination order continues along with 2 crores fine. I deserve the power to enhance the penalty. I have been terminated. Director says, no, your license should be terminated. It will continue. Again, 2 crores rupees fine. Enhance the punishment. C. Impose any of the other additional penalties provided under this order. Any penalty. 50 rupees fine, papered appeal, 50 rupees fine will be continued along with your license is terminated. Because I preferred an appeal. Enhance the punishment. Whatever punishment recorded in the chapter 9.
There is no provision regarding setting aside the earlier order.
No, I am not fining. Enhance any of the penalties. Then now we can only come to 58. Not least, see, show moto power of review. The secretary may show moto upon a representation made in this behalf, call for the records related to the person under provision so and so, the licensing authority, and be satisfied that the authority has exercised such power so and so, exercised such power so and so, so and so. So there is a power of review also. Show moto. After my termination, I went to the first appellate authority. He imposed termination continue 50,000 fine. Second appeal, termination continue 50,000 fine, another 1 lakh. Then I thought it fit not to go proceed further. Suo moto review, again punishment, 1 crore. Had I stopped with the first instance, it may be only termination. Ridiculous, I am telling you, Your Lordship. This is ridiculous. No prudent man can accept it. What more example? Unreasonable, unfair, unjust, unfair, everything. This is arbitrary. Enjoyment of power. Never suggested by 2015 control order. Inconsistent to central control order. But all Supreme Court judgment says the state cannot make a policy which is arbitrary, unreasonable, unfair, unjust, contrary to any logic, and violation of fundamental right, and contrary to a constitutional right. My capital punishment without show cause. After 30-40 years of running my business with unblemished career, of the record, I am saying it is going on in Food and Supplies Department. Your shop will be inquired on particular day. Please come and contact me. I am not enlarging this submission.
So first appeal, second appeal,
Then review. Show
then
moto.
review.
Show moto review. I have no power to review.
In the first appeal, there is no authority to resign the order.
Yes.
But in the review, there is a power to resign the order.
Yes.
Only in the review,
Only in the
last stage,
not first, not second.
in the last stage, the order may be resigned.
I just submitted Your Lordship ridiculous. I don't know who has drafted it. But 100% sure it has not been placed before any of the learned advocate, Upper High Court. I shall show why I am submitting this particular sentence from the division bench order. Now, Your Lordship, kindly see the inconsistency. Page 61. Page 61. Targeted Public Distribution System Controller 2015, framed by the central government. It starts from page 42. I am relying upon Your Lordship, page 61. This is definition. Now, kindly turn to page 60 first. Licensing and regulation of fair price shops. The entire provision has been given. State government shall issue an order. I have shown to Your Lordship, need not go through the same. How the license shall be given, how the control order shall be framed. Now, kindly state come to subclause 5 at page 61. The license to the fair price shop owner shall be issued keeping in view the validity of the fair price shop. Viability. Every day in Your Lordship's court, there are cases. I have only 4,000 ration cards. It is economically unviable. Central government says at the time of granting license, you have to see that the dealer which is going to be appointed should be given number of cards which is economically viable, make the business economically viable. I have 5,000 ration cards. It is your whims. You are giving a new appointment. By curtailing 4,000, I have nothing to say. Statute does not allow me to make any submission. Dealing 4,000, you are a bad person. You are not coming to my office every day. I am not enlarging. So 4,000 card will be dealing from your dealership and it will be given to the newcomer. Statute does not protect me. It is the whims and choice of the licensing authority. How much number of cards shall be given to a dealer? How much number of dealers shall be tagged with a distributor? Totally him. 2 dealers, one is running with 12,000. Just besides him, in the same location, only 2,000. There are number of references. One distributor is running with 80 dealers. One distributor is running 12 dealers. Just besides, same location, vicinity. Whims and choice, no restriction. Central government says you have to see to make the dealership and distributorship business, this number of cards are required. This number of dealers are required for distributor. Nothing in the 2024 control order. Your Lordship dealing this type of matters every day, then kindly see 6. The state government shall ensure that the number of ration card holders attached to a fair price shop are reasonable. Strengthening my submission so far the clause 5 is concerned. Reasonable means economically viable. A man can run his business by keeping some employees with infrastructure, by engaging employees. Today, my lord, your lordship knows everything is computerized. So I have to keep a educated person. I have to make payment of him as salary. Infrastructure, 2 shops, carrying goods, duration scheme. Another person, because every day duration scheme. So 1 person in shop room, another person is moving, at least 2 persons. Computerized known person for using this
data entry.
Data entry. Well, I am not so conversant. But this is not inconsistent. It has been advanced on behalf of the state that there is no inconsistency. 2015 and 2024. The basic thing at the time of appointment, at the time of detagging of cards. Let's get. অত দেখা দেখা যাচ্ছে টাকা পয়সা দিচ্ছেন পুরো মামলা ছাড়া একটা পেন।
Yes.
There is a provision for review of the margin. My lordship juniors are insisting me for showing that, but there is no review till today. And that case is pending before your lordship. Mr. Advocate General paid for adjournment today. And so far merit is concerned, before going to the merit, just one judgment I shall place before your lordship. Before Bridgemont, that's my fantasy judgment I shall place definitely before your lordship, but kindly see the division bench order. On last auction I have handed over, again I have handed over. Learned Advocate General says that the order passed by your lordship has been quashed and set aside. Definitely it has been quashed and set aside with some observation. Kindly come to page 5. Before going to the page 5, I have just submitted before lordship that this draft control order 2024 definitely has not been placed before the hearing of the learned advocate, at least before the learned advocate general. Why I am saying so, kindly come. Page 5. Your lordship has quashed and set aside, stayed the entire chapter 9 penal profession. They preferred an appeal with the specific point that the point of maintainability has not been dealt with by the learned single judge before your lordship, although you have raised the points. Kindly come to paragraph 17.
Yes.
At page, this court is of the view that the maintainability issue about level being inclusively decided by the learned single judge before venturing to pass an interim order. Then this is the point. Then kindly turn the page 6, paragraph 22. This is an assurance by the learned advocate general. This court records the assurance of the learned advocate general for the state that the principles of natural justice would be duly complied with and followed while applying penalty provisions to the fair pressure dealers in the state. It is our case. Principle of natural justice show cause reply that has been undertaken before the division bench, none other than the Advocate General. He thought it fit also that should have been. Next paragraph, kindly read. It is made clear that the state shall not be prevented from making any changes and or amendments or modifications to the control order of 2024 as it may seem fit and proper to ensure the conformity with similarly subordinate legislation already framed in the state and after parts of the so and so. So during pendency of the writ petition, state has also been granted liberty to amend the control order if was necessary. Why? This penal provision has also been considered. Division bench thought it fit to quash the order on the ground. Point of maintainability should have been taken first. With the observation and assurance from the learned Advocate General that at the time of penal provision, you shall follow the principle of natural justice, meaning thereby issuance of show cause and reply to that. And also cautions that you may modify. Why the question of modification does arise? The division bench thought it fit that this chapter 9 is violation of principle of natural justice. Because only that point your lordship has stated the order. So you can modify it. It's the thinking of the division bench. Yes. The Bridgemohn Lal, I shall definitely place before lordship, paragraph 100 and 101. Wait on that. Your lordship, note these are the provisions. Just I'm handing over the particular paragraph. And the paragraph 100. These are the 6 ingredients when policy of the state can be challenged. Okay. Bridgemohn Lal, your lordship. Take note of 100 and 101. Your lordship dealt with this judgment in numbers of cases. The PML. Which is so the submission of the state that policy cannot be challenged or subordinate legislation. Is that not the law possibly? I have shown to your lordship.
Yes.
But only I am just concluding my submission by handing over the PML part of the National Food Security Act 2030. I am requesting your lordship to go through the same because this is a new concept in the book which I have annexed. This PML part was not there. Just there is a I'm requesting your lordship to go through this. The concept of targeted public distribution system will clear after 66 years of the independence. The new concept, TPDS. All old concepts of BPL ration cards, APL ration cards goes. Now only eligible households. And the number of consumers in all states are fixed. I have shown to your lordship. Quantum of allocation is also fixed, which will appear from control order, National Food Security Act. Entirely new concept. You cannot go beyond the scope of this TPDS. Okay. So before conclusion of my submission, once again I am submitting my lord. So for the point of maintainability is concerned,
yes.
Although I have relied 2-3 judgments, my specific case is that it is barred by principle of constructive res judicata in terms of section 11, classification 4, and judgment I have also relied. Even then I have argued the case for the sake of argument, and so far the merit is concerned, possibly I have tried my level best to show before your lordship that demonstrate that this is the arbitrariness, this is the unreasonableness, this is the unfairness, this is the unjustness, and contrary to all policies, violation of the fundamental right, without any logic. Well, these are my submissions.
Yes.
Mr. Datta has said that if necessary, your lordship may call him.
My lord, can you fix the date for reply, my lord?
Reply.
Yes,
I am
my lord,
giving
that is
reply.
the instruction, my lord. Mr. Bandyopadhyay has told me.
The Datta
that
has
is my
submitted before lordship. If necessary, your lordship may call him.
My lord, kindly fix the date.
Today he has submitted before lordship. In that case, I have to give him again reply. I don't know.
When the other matter is fixed on 22nd. 22nd.
Transport rate. It is fixed today also at item 7.
Yes.
You have fixed it on
22nd. Let this matter be also fixed on 22nd.
It is fixed fit, your lordship.
Let the matter appear in the list on 22nd of May 2025 at 2 p.m. as a special fixed matter.
It will, Mr. Datta has come, or possibly have to 10 to 15%.
Yes, only 10 to 20.
And this matter has not been treated as hard in part. Kindly treat is hard in part for benefit of all the councils. Possibly it has not been treated as hard in part.
Not hard in part?
No. So, almost conclusion part. Conclusion হয়ে গেছে।
Concluded.
কি লিখলো? Order লিখেছে কোনো? My lordship may record that I have concluded my.
It is
hard
hard in
part.
part.
My lordship kindly record that I have concluded my.
Yes. Lekho.
I have given my reply. Kindly record it.
Petitioner has petitioner's argument concludes. Let the matter appear in the list on 22nd of May 2020.
But item number 1 at 2 p.m. because it can be disposed
for hearing. Hearing learned advocate general on reply on the point of maintainability.
My lord, point of maintainability. I'm grateful. Much appreciated. Hard in part already. Just দেখে বললেন. It is hard in part already.
Yes, already hard in part.
Can it be item number 1 at 2 p.m. because so that it can be concluded if Mr.
Yes, that with this matter will taken up fast.
I'm getting.
I want learned advocate general be there.
Yes,
that's why I fixed the date of 22nd.
Already his 2 matters have been fixed. One Mr. Torupdas matter and mine also. I'm getting.
For the list. Six 19.5. 19.5. It was fixed on 19th May.
My lord, and honorable court directed me for a petition service. I have already made the service, and this is the service along with that ruling. And this first part, second part, my lord, I have filed the can, that can I have paid for restoration of my WPA and call the order. My humble submission, I did not know what the previous lawyer has said in my absence, without my knowledge, keeping me totally in dark. Under these circumstances, if it is not recalled or not restored my case in its previous version, then I will be deprived of justice and I will be highly prejudiced. In no way it can be compensated. That's why my humble submission before your lordship that kindly restore my case in its previous version and recall the order of disposal.
Yes, you are appearing on behalf of.
I am appearing on behalf of the earlier advocate on record, Mohammed Idris. He has personally requested me over the phone and he has also sent me a WhatsApp message. He's undergoing surgery, 2 surgery were there. Now it is malignancy is found. He is under treatment. He requested me to pray before your lordship on his behalf. In what circumstances it has been given, I don't know. I don't know the merit of the matter also. I only, if it is possible to hand over your lordship the type of his WhatsApp message.
None necessary.
Please before your lordship, if that is be recalled, he cannot have any objection, or if any reply is given by the concerned learned authority, he may be allowed some time to file any affidavit. At least chemotherapy is continuing. At least 6 months time is required, as I have taken from you.
Now the issue is that whether you have served upon Jahanara Begum.
My lord, I went to serve it, but that time Mr. Idris Ali, the previous lawyer, told he was my junior, but now he is not here, and I do not know his phone number, and I do not know his address, and where he is seated in the High Court, that also I do not know, so I can't say anything about her. That is Jahanara Begum. Later on, my lord, the surprising thing is this: 7th May, date was fixed. 6th May at night, that Jahanara Begum phoned me. Why it is like this? I have served someone. I have not served someone on notice. As per the court's order, you first receive it, and thereafter you can ask me anything about the case. And in this stage, you cannot ask me first to receive it. Still, she did not receive it and never come to my chamber. Where I will search her, and the only this I got, I served him 2 times. First time, second time, and also honorable court directed me to serve the notice to the GP. That I have also served. His junior, his intern, both received it on behalf of the GP. Government leader. I have written it, everything.
One Miss Jahanara Begum appeared before this court on 26th of February, saying that he led by advocate on record Muhammad Idris.
I'm appearing for the state, Your Lordship.
Yes, and on instruction of the petitioner,
yes,
they doesn't want to proceed with this matter. That's why the writ petition was disposed of as not pressed.
Yes,
this is the issue here.
Today,
What is your submission?
during lunch, I have received a phone call from Janara Begum. I asked him where you are, asked her where you are. She said, she has not come to the court today, but she requested some of his learned member to represent her before your lordship. This is her submission. But I am today before your lordship on behalf of Muhammad Idris, because we sit in the same room in a different chamber. I knew him for quite some time. He personally told me due to his illness, he is not also attending the court. We are also trying to recover him for his illness.
So what is your submission regarding the application? Can 1 for recalling the order?
As he written instruction,
he has no objection.
He has no objection. The Honorable Court is to recall the earlier order of withdrawal.
For the state, Your Lordship, the fact remains, once the matter has been withdrawn without leave, Your Lordship, can that be at will the wishes of the petitioner? Can that be recalled, and again the matter can be done, or a fresh writ petition can be done? That has to look into, Your Lordship.
No, this is as I have understood, this is not the fair response. Same writ petition will be revived.
It's absolutely, Your Lordship. Once the matter has been withdrawn without any leave, Your Lordship.
My lord, if keeping the dark to the petitioner, everything is gone behind back. How it is not possible? Court is here to provide justice. If this mistake has been done by the lawyers himself, not by the petitioner, petitioner is nowhere liable.
There is not the fact that the petition, erstwhile petitioner has perhaps given a year that he has no objection, but he has not, the erstwhile petitioner, the advocate has not accepted that he has submitted without
So,
instruction.
madam, this matter to be dealt with by the competent authority who has given the proper instruction, why the matter is done with that, why the instruction is appear before this court. I will delegate the matter before the competent authority regarding the complaint against the learned counsel.
His candidature was rejected, Your Lordship. Admittedly, he did not.
That is the merit of this matter. That is.
I shall produce report, Your Lordship. That is not a fact, Your Lordship. The fact remains once a petitioner withdraws his or her application, Your Lordship, where I may come up with judgments where on oath they have come up with an application, the matter has been withdrawn by them without any liberty, Your Lordship. Can they come up with an application to recall that order?
What the result? What the result?
The advocate has
No,
submitted.
just wait, let him submit. Why are you arguing like
It
that?
has been submitted by the advocate appearing, erstwhile advocate appearing for the petitioner, that he has been instructed to withdraw the matter. The matter was withdrawn without any liberty, Your Lordship.
Now petitioner came and say, I have no instruction.
Yes, that is the point. Can a petitioner come up at whims and wishes and once say to an advocate that I want to withdraw,
So,
and then come
so
up to another
it
advocate
is
and say
true.
I didn't give?
No, it is true. One person must have tell false. One person must have false. Either first party, either first learned advocate or second learned advocate.
Your Lordship, the erstwhile learned advocate does not admit that he had made false statements, Your Lordship. This
No,
is
that matter cannot be inquired by this court.
Absolutely, Your Lordship. But I shall indicate on the next. Your Lordship will keep this matter any day, tomorrow or day after tomorrow. I shall bring in judgments if once it has been withdrawn. A recalling application, can it lie at all? I shall produce that. It may be considered by the authority, Your Lordship. That is not an issue. But this will set a precedent that once a petitioner comes up and withdraws the matter and then again files a can and says, no, I didn't give no objection, blaming the advocate, Your Lordship, the fraternity will be at stake, Your Lordship.
So
In
whether
future,
you
this will
want to
set a precedent.
whether you want to use the affidavit against this or you want to argue on that point.
If Your Lordship pleases. Or Your Lordship will keep it on any day next week or after vacation, I shall argue the matter.
May I be permitted to say something, my lord?
Yes.
For 1 minute. On previous date, that is 7th May, the petitioner personally came with a minor 2 years daughter before the Honorable Court. If Honorable Court asked anything, any question to me, because that date, my
The court is not the query. This note is the place for query or do that matter like that.
I know, my
Then,
lord. But question
why
raised
are
on
you-
that date.
No, he asking the question on point of law.
I
You have to answer on that point.
On question
I am not going to the merit of this matter. Who take the instruction, who has not the instruction.
My
That
lord,
is all separate issue.
with deep respect,
Not
I
to be deal
understood.
with this matter.
I understood, but that's why I am giving that ruling Supreme Court. If the fault of the lawyer, why client
Your
should
Lordship, the
suffer?
fault of the lawyer has to be proved.
1980,
Has the advocate
1981
admitted?
Supreme Court, yeah, I have given already.
Your Lordship, has the erstwhile
Is there any
advocate
fault?
admitted?
Is there any fault or there is any instruction like that? A party cannot change his instruction like that before a
I
court.
don't know, instruction I have given, that's why I
Okay,
came.
okay, that has to be there to it.
Your
Okay,
Lordship, my one question is, has the erstwhile advocate admitted that he has submitted without instruction? He
Sir, you
notices,
need
no?
to give me.
He has said he has no objection in recalling. I shall make.
Let me repeat. I request you to appear on behalf of I filed the writ petition. Please pay time for me due to my major
Yeah, sure.
undergone
Competent authorকে delete করতে না পারলে?
I have to take I have to take rest for 4 months. Not 6
if you
months.
want to read with this, you read it. Otherwise, you need not to place before this court. If you like to read it, read it. I am placing a date. Please take it.
Please take it.
No, this instruction cannot be taken like that.
There's no signature.
No
Your Lordship,
signature, nothing
nothing.
is there.
এটা
That's
হোয়াটসঅ্যাপ
why I am
মেসেজ
not
ছিল
taking
রে বাবা, আমি প্রিন্ট আউট করেছি, এটা আমাকে পাঠিয়েছে।
Has the advocate admitted that he has made wrong submissions?
That is his matter, not my matter.
Sure, this will set a wrong precedent. Your Lordship, any client will come up and say, I didn't give.
Learned counsel appearing on behalf of the state raised strong objection against the application being Can 1 of 2025 and submits that the state shall use affidavit against the application. Let the affidavit be filed within 1 week after vacation. List the matter for hearing under the heading to be mentioned on 16th of June.
Grateful, Your Lordship.
June. 16th of June.
No.
On that day, may I be permitted to be present here because Mohammed Idris is not able to come on that day also.
Lordship, may a date be fixed where the erstwhile advocate is
It's not
able to
possible.
bring
He is under
representative.
chemotherapy.
He is admitted there in the hospital. How can he come? As you have raised a point of law, I have to deal with that only.
He is using the catheter. It is not possible to.
Grateful, Your
You just inform him that
I will
if there is any instruction, I want
Under
to
his
know
name.
whether Mr. Muhammad Idris had any instruction from his client.
He may file a notarized affidavit, give it on affidavit.
Not necessary, just you take the instruction. Very well. Next.
It is my petition, my lord. Should you kindly recollect the last occasion when I appeared? So two content petitions, CPAN 805 of 2018 and CPAN 68 of 2019. Lordship, on the last occasion, directed both the matters to be placed together.
Where is the other matter?
দুটো ম্যাটার থাকবে একটা 805 of 18 আর একটা 68 of 19
কোথায় 805 কোথায় অর্ডার ছিল 805 টা আসবে এর সঙ্গে কেন না কেন এসছে দেখুন এসছে কিনা মধ্যে আসেন না কেন অর্ডার করা আছে তো রিকুয়েশন করেন
সিপান এটাও সিপান সিও থেকে রাইটস
I have heard the matter. Only the record is required to pass the order.
Yes. And Lordship directed that both the contents should be placed together so that
আসে না কেন Where is it? কালকে প্রেস করব tomorrow same heading both the matters positively
I'll come back.
Call next matter.
I'm appearing on behalf of the respondent number 14 and 15.
Opposite party. Civil division, opposite party বলুন।
Opposite party number 14 and 15. Southeastern Rail.
Lord, I'm appearing behalf of the opposite party number 1. The election already held. And
Kindly fix the any date.
Why? This is the fixed date.
Right now the matter is going. That reason I'm praying you. Kindly fix the any date.
What is the CU about?
the matter regarding Lord, there is the election of the union. Lord, they filed a suit and obtain an injunction order. Lord, against that injunction order, we preferred an appeal before the district judge. District judge directed to election be conducted. But their election already held, and Lord, the office bearer already elected. Lord, thereafter, Lord, they filed the distribution and application
Against the order of district judge.
District judge. This election already completed, and on the basis of that election, Lord, the parent body election already
After vacation?
After vacation.
Okay. Let the matter appear in the list after 2 weeks of vacation.
Okay.
Call item number 23.
23, Your Lordship. I'm led by me, Sheboti Dutta. Lordship, this matter is appear for the first time. Lordship, kindly direct me to serve the copy to the other side.
What is the matter? Why the contempt?
Yes, Lordship, it's a contempt application, Your Lordship.
Contempt application? Why it is appearing before me? Okay, all the contempt will assign contempt matters. It is running since 2018.
Yes,
Is there anything
No, Lordship.
remaining
No, Lordship.
for issuance of contempt? What is the matter? What is
Lordship,
the order?
as per instruction, this matter is come first time, Your Lordship.
That's why I'm asking what is the merit of the contempt. You have to apprise this court regarding the merit of the contempt application after these long years. 2018, you have filed the contempt application and keep it silent. What is the purpose of maintaining the contempt application now?
Lordship, kindly fix any date, Your Lordship, because
After vacation. Let the matter appear up 2 weeks after vacation. 2 weeks after vacation. So what are
Lord, 24, I beg to appear on behalf of the petitioner, Lordship. My Lord, in the earlier occasion, your Lordship was pleased to direct, my Lord, on 11th of April 2025, was pleased to direct me, my Lord, to serve the copy of the contempt application. My Lord, it was duly served. My Lord, this is the affidavit of service. Lordship may kindly recollect, my Lord, this matter, my Lord, pertains to, my Lord, execution of mining lease deed. My Lord, what happened, my Lord, before this honorable, my Lord, bench, my Lord, presided over by my Lord Mr. Justice Harish Tandon, my Lord, in the year 2018, my Lord, there was a specific direction, my Lord, for joint inquiry and to submit a report, my Lord, after the inquiry, whether the disputed land, my Lord, is falling within the jurisdiction of state of Orissa, or if it at all falls, my Lord, how, my Lord, what is the portion of land, my Lord, falls within the state, or my Lord, if it is within the state of West Bengal. That was, my Lord, the sole order, my Lord, passed by, my Lord, this honorable court. My Lord, if your Lordship kindly comes to, my Lord, page 21 of my contempt application. Rather, my Lord, page 20 it starts. My Lord, the operating portion is at page 22.
Yes.
Lord, may I just read? Since the physical verification would close the issues so raised in the instant writ petition, this court does not find any justification in taking a dissenting view to what has been taken by the coordinate bench in the said writ petition. Accordingly, this court directs the state of West Bengal through its appropriate agencies to cause a joint inspection of the site in question along with the representative of the petitioner and the report shall be filed by the respondent number 4 in the form of an affidavit stating the outcome of the said joint inspection and the report submitted by the inspecting authorities. It is open to the state of West Bengal to inform the competent authority of the state of Odisha to be a part of such joint inspection so that the land or site in question, whether falls within the state of West Bengal or Odisha, can be resolved. The respondent number 3 is restrained from making any further action for fresh auction in respect of plot in question for a period of 8 weeks from the date or until further order or orders of this court, whichever is earlier. So, my lord, this was the interim order passed. Now, my lord, what happened, my lord, challenging this order, my lord, the state of West Bengal, my lord, filed an mandamus intra-court appeal, my lord, which was disposed of subsequently. Lordship may kindly have a look to, my lord, page 25. My lord, the order dated 21st of January 2025. This honorable division bench, my lord, affirmed, my lord, the order passed by my lord Mr. Justice Tandon and was pleased to direct the same thing, my lord, at page 28. Indisputably, the sand mining block of one so-and-so and the sand block in respect of which the respondent had been the successful tenderer were put up for auction vide NIT dated so-and-so. Upon inspection by the respondent on the basis of the GSP coordinates provided in the NIT, the block was found to be situated on the other side of the Subarnarekha River, which was in the state of Odisha. The court passed an order towards inspection in the case of so-and-so pursuant thereto. An inspection was conducted and ultimately, upon obtaining necessary clearance from the appropriate authority, the lease deed was executed in favor of so-and-so on March 15, 2024. In the said conspectus, and as both the sand mining blocks are in the district of Paschim Midnapur, no different stand could have been taken by the appellants. For the reasons discussed above, no interference is called for in the present appeal. So, my lord, FMA so-and-so was dismissed. So, my lord, the ultimately, my lord, Mr. Justice Tandon's order was affirmed by this, my lord, division bench. Now, my lord, till today, my lord, since 2018 till today, my lord, they have not caused any kind of joint inspection, my lord, so that.
What is said, the inspection has been done?
No. My lord, that was in another matter. My lord, in MDTNB 16, my lord, Shankar Das, that was the writ petitioner, my lord, there. He was the writ petitioner there. So in that case, they done joint inspection. But in this case, they are not doing. My lord, the same, my lord, block, my lord, it was 16, and my lord, in this case, it is 22.
So petitioner is Alokesh Singha.
Yes. And this, my lord, was Shankar Das.
No one, is there any appeal against Alokesh Singha?
Yes, Alokesh Singha, my lord, state, my lord, went up in appeal. My lord, the order, my lord, I was just reading.
Yes,
My lord,
Alokesh Singha.
your lordship will get at page 25. The order starts. My lord, FMA 802 of 2020. State of West Bengal, my lord, went up in appeal. Page 25. My lord, the order, final order was passed on 21st of January 2025. So, my lord, their appeal was also, my lord, rejected. Now, my lord, till today, my lord, they have not done, my lord, the joint inspection. And your lordship in the earlier occasion was pleased to, my lord, direct us, my lord, to serve, my lord, copy. And, my lord, in spite of, my lord, the delivery, my lord, it's showing, my lord, it is delivered to the addressee. My lord, they are not appearing. If your lordship kindly, my lord, I am seeking, my lord, for issuance of rule, my lord. My lord, specific direction was passed by this honorable court, my lord, at page 22, my lord, upon respondent number 4 and respondent number 3.
Whether any fresh auction was taken?
Yes, my lord, fresh auction has been taken by, my lord, a separate entity which has been formed under the 2021 rule, my lord, WBMDTCDCL, my lord, it is called, my lord. They have, my lord, caused a fresh auction in respect of this particular, my lord, block. My lord, we do not know whether this block or not because no specific number has been mentioned. But, my lord, it is showing, my lord, Subarnarekha river adjacent, my lord, land, plot of land. My lord, I have that copy also, my lord. I have used a supplementary affidavit, my lord, in the main writ petition. My only grievance before your lordship, my lord, if, my lord, demarcation is done, my lord, we will be able to know, my lord, whether it is within the state or without, my lord, beyond the state.
Whom you serve the application?
My lord, I have served, my lord, on. না না জজ সাহেব ওটা দেখতে চাইছেন কবে Lord, I have sent Lord on 17th of April 2025, and if your Lordship kindly sees Lord the track report, page 8 onwards, Lord, it shows Lord item delivered to addressee. On 19th of April, it was Lord delivered. One is Lord on 19th of April, Lord. The second one is on Lord 21st of April.
Whether they are there?
Yes, yes, Lord.
They are the designated persons there.
Lord, they are the incumbent there, Lord. There is no change, Lord, after that. They are the present incumbent, Lordship. Lord, my humble submission, Lord, they are deliberately, Lord, avoiding, Lord, this. In spite of, Lord, repeated orders, Lord, passed by this court.
ফরম্যাট আছে একটা রুল ফরম্যাট আছে
ফর্মটা হয় এই ফর্মটাকে ভরে দিতে হবে এর একটা ছোট ফর্ম হয় সেই ফর্মটাকে ভরে দিতে হবে জজ সাহেব রুল ইস্যু করলে রুলের ফর্মটা ডিপার্টমেন্ট ডাকবে তখন ফর্মটাকে ভরে দিতে হবে
বসুন বলছি হ্যাঁ আপনি affidavit of service filed on behalf of the petitioner is taken on record. Full stop. It appears from the affidavit of service that the application being CPAN 583 of 2025 along with the copy of this order, copy of the order of this court dated 11th of April 2024 was served upon the 11th of April 2025 was served upon the alleged contemner. Full stop. Despite service, none appears on behalf of the alleged contemner. Considering the situation, this court finds it justified to issue rule in favor of the alleged contemner. Let the rule be issued. The rule of contempt be issued upon the alleged contemner. Made it returnable on 24th of June 2025. 24th of June.
Lord, may it be sometime before that, Lord. Subject
that.
to your Lordship's kind convenience.
Vacation is there, you know.
Lord, we are reopening, Lord, on Lord, sometime in Lord, third week, Lord, subject to your Lordship's
So
kind.
it is there. June, okay, third week. First week is the entire holiday.
Yes, Lord. Lord, second week we are reopening, Lord.
They must have given at least 2 weeks opportunity.
As your Lordship
After
pleases.
vacation.
As your Lordship please.
Department to do the needful to issue the rule according.
Grateful to your Lordship. Lord, the affidavit of service may be kept.
Affidavit of service be taken on record. Next. None appears on behalf of the petitioner. No accommodation sought for. Let the application being CPN 486 of 2020 be dismissed for default.
My lord, item number 27, I am appearing for the petitioner, my lord. I am being led by Mr. Anirban Ray. My lord, I am seeking for an accommodation made the matter be for tomorrow. Mr. Ray will come and submit before my lords.
After vacation.
Much obliged.
After vacation. List the matter after vacation. Next. None appears on behalf. No. None appears on behalf of the petitioner. No accommodation is sought for. Instant contempt application being CPN 466 of 2021 is pending since 4 years. Considering the situation, considering the long pendency of the instant contempt application and the conduct of the petitioner, let the contempt application being CPN 466 of 2021 is dismissed for default. Same order, dismissed for default. Next. Same order. Similar order, dismissed for default.
My lord, appearing the alleged content of the order has been complied with, my lord. ওটা দিন ওটা দিন ওটা দিন ওটা দিন কমপ্লায়েন্স রিপোর্টটা দিলাম আমরা নিচেরটা compliance report
regarding compliance.
Yes, my lord. Already, my lord, the variations of the Borkadar has been included, but the recording correction of record of right is concerned, my lord. We send these matters before the ADMLers. It will take some time, at least, my lord. Page 4, my lord. Compliance report. Ananta Mondal files make a determination of the requirement section 15A of the report of the concerned revenue inspector along with the documents and variations submitted by the petitioners as an officer empowered under section 18(1) of the WBLR Act 1955 nominate the petitioners Haripada Mondal son of Ananto and Varisan Borgadas, and recorded Borgadas. Ananta Mondal against them marginally noted in his orders, and Horipada Mondal, Ananda Mondal, Varis Borgadas, and recorded Borgadas.
Where is the order? Page?
Page my lord 4.
Page 4.
That is the operative parts, ma'am. 19th March 2025.
19th March 2025.
And last portion, my
In
lord.
terms of the direction of this court.
Code, my lord.
15A.
15A, my lord. And it is ordered that the Horipada Mondal last portion, my lord. Page 4, my lord.
Yes.
It is ordered that the Horipada Mondal, son of Ananto as Varis Borgadas, or recorded Borgadas Ananto Mondal, son of Pitambar, and record in the module under the corrected according to as per the technical provisions laid down therein, the case is disposed of. And my lord, the next page, page 5, my lord, to the additional district magistrate and district land reforms officers, subject prayer for the approval of the, there is a recording of the server record, my lord. And he might not come to the page 1, my lord, to correct the Borgadas name in the computerized section land record through software against the Khotiar number 2823, 2830, 2831, 2839, plot number 535, Mauja, such and such. And the case number is theirs. And after receiving the approval from ADM and DLRO Purbo Midnapur, and computerized land records will be corrected as per the order sheet, and the order of the Honorable High Court will be complied with, one. And that was uploaded to the server, my lord, page 7, 6 onwards. 6 onward, my lord. 6, 7, 8, 9.
The server.
Server, my lord. And it will be take some time, and that will be uploaded. কেসটি DLLR অনুমতির অপেক্ষায়, my lord. That will be middle portion.
Yes, what is your submission?
After passing your lordship's order, they have initiated the procedure, and as per their report, lordship, today they have submitted. Order has been complied with.
I am disposing of that CPA.
My humble submission, lordship, kindly direct them to file a computerized record, lordship. It will be required, lordship.
Yes, we can have the record in the online.
Till now, their statement is
Direction is upon block land and land reforms officer EGRA 2 to pass an order. The order has already been passed.
Order has been passed, but finally public record is required, lordship. Otherwise,
you will take the record according to the law.
Yes.
According
no,
to
unless they submit the
yes, we already uploaded.
Unless they uploaded this records, lordship, we cannot obtain this copy. So that should be done within any specific time, lordship.
This is out of the ambit of the concept. However, please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Mr. Amritulal Chatterjee, learned counsel appearing on behalf of the alleged contemner, submit a report regarding compliance of the concerned authority by virtue of order of a coordinate bench of this court dated 24th of November 2021, passed in CO 1569 of 2020. Full stop. It appears that in terms of the direction, block land and land reforms officer EGRA 2, Balighai, EGRA 2, Balighai, district Purbo Medinipur, has passed an order disposing of the application filed by the petitioner under section 15 capital A of
West Bengal Land
WBLR Act. Block West Bengal WBLR Act 1955. West Bengal Land Reforms Act 1955. Okay. On 19th of March 2025.
Yes, well.
Peruse the order. Full stop. It further appears that after passing the order, the matter was placed before the concerned additional district magistrate and district land and land reforms officer Purvo Mednipur for correction of record of rights.
Lots.
For the purpose of correction of record of rights, they have initiated some miss cases and through online required information and necessary sanction has been placed before district land and land reforms officer. Current status of the portal has also been placed with the compliance report. It appears that the final record of rights was not prepared yet. Full stop. Next part, Learned Counsel for the petitioner submits the necessary direction may be passed upon the concerned authority so that the record of right may be published as early as possible. Full stop. Having heard the Learned Counsel for the parties, it appears that the alleged contemner has already complied with the order passed by this court. Its order dated 19th of March 2025. Hence, I find no justification. Now, as the order passed by this court has already been complied with, so there is no merit to proceed with the instant contempt application. Thus, the contempt application is disposed of. Next, by rule, if any, rule issued, if any, is hereby recalled. Full stop. The authority concerned is directed to publish the record of right according to the law as early as possible.
Grateful, my lord.
Contempt application disposed of. CPN 600 of 2022 is disposed of. Report of compliance is taken on record.
Grateful, my lord.
Our disposal. No. This for the matter.
All the matters?
No, I'm appearing for a contempt. Matter has already been disposed of. 14/9/2023. Justice Amrita Sinha. Lordship kindly see Justice Sinha's person order.
You are appearing on behalf of whom? Alleged contemner?
Alleged contemner.
Who is the petitioner? Where is the petitioner?
Disposed of, that is why, my lord, no petition is not appearing.
Disposed of. Which matter you are? Honorable Chief Justice's order.
Well, this is the order.
November 18, 2020. Passed in CO number 1324 of 2020.
November 18. No, here.
November 18.
Here, 14 September 2020.
No, other matter. What are the
CPN number 733.
Yes.
And WPA number 23292. Lordship, kindly see, my lord. This is the order I got it, my lord.
No.
A soft copy of the order, Lord.
CPN number 733 of 2022. In connection with CO number 1324 of 2020.
No, WPA 23292 of 2019.
You get this?
Lokshikanta Ghosh.
Mr. Devray?
Yeah, I goes.
Where from you get this?
I have this order, my lord. Soft copy, my lord, my client sent me.
No, that is wrong order. This is CO 1324.
Oh, CO matter, I don't know, my lord.
This is CO matter.
I don't know. I'm extremely sorry, my lord. I don't know that.
Are you in this matter? No, you are not in this matter.
No.
Number perhaps you have.
This number is Rashikant Ghosai. দেখেছো? পার্টির নাম জানো? বার করো।
None appears dismissed for default. None appears dismissed for default.
Right.
কম্পিউটারে নো রেকর্ড দেখাতে হবে না, কোথায় আছে বের করো, কালকে বলতে হবে তাহলে।
পোস্ট টাইটেল সেম।
দেখুন সার্চ করে দেখুন।
This is what default. আচ্ছা, তার নামটা দিয়ে।
Millard, may I be just permitted to indicate the item number 8?
Item number 8, 9, 10.
8, 9, 10. Millard, the Huda is here.
Yes.
And if your lordship so desire, I can continue today, Millard. And or if your lordship so desire, lordship can fix it any other day, 7 except tomorrow.
Mr. Huda would be not available tomorrow.
No, I tell you, lordship, Mr. Huda, I understand the difficulty. Mr. Huda has made his submission. What I have to reply to that.
No. They are to make submissions on maintainability.
Yes, point of maintainability.
Yes.
You are
All right, very well. On the point of maintainability in that event, if your lordship so permits, I can demonstrate right at this moment.
Yes.
I have no difficulty to that extent. If your lordship so agreed, I can continue.
Let's do it today, my lord.
Well, I have no difficulty. Subject
Yes,
to
you start. Item number 8.
In that event, lordship kindly release all other matters. The learned advocates are.
Already I have 5 minutes on.
No, I will continue.
Yes. You start.
Excellent. Now, Millard,
yes.
Huh?
The constitution আমাদের পরে এখন না আর্গুমেন্ট করছে পরে।
Millard, first of all, the beginning of my argument would be in our constitutions, Millard, we are duty bound to provide some of the services. Millard, this power basically coming from the state directive principle. If I read the article 39, lordship kindly have a look into 30. May I just show to your lordship?
39B.
39B. Yes, the lordship knows. 39B speaks of that the ownership and the control of the material resources of the community are so distributed as best to subserve the common goods.
Yes.
Kindly pause here for a moment. The intention of the legislature was to serve the purpose of the same and to give the best service to the common people at large, according to my understanding of the millet section.
Yes.
Now, kindly see kindly also take trouble to see Article 47.
Yes.
Constitution. Now, this article speaks of the two parts. One is the prohibition part. One is the millet rising of the nutrition part. If I read this, Lordship would see the duty of the state to raise the level of the nutrition and the standard of the living and to improve the public health. This is the primary contention. Now, kindly see what has been written. The state shall regard the rising of the level of the nutrition and standard of the living of its people and the improvement of the public health as among its the primary duties. Pause here for a moment. Kindly pause here for a moment. The latter part is the prohibitory part.
Yes.
Prohibitory part in respect of the millet intoxications. So, the balance, equilibrium of the balance is very simple. You have to keep the balance in a proper manner. In one hand, the intoxication things has to be controlled. On the other hand, the nutrition level would be upheld. This part is applicable to the liquor pots and other things which is known as res extra commercium. But the first part which speaks about the level of the nutrition,
Rising level of the
rising level of the nutrition,
standard of living of its
correct. This is the millet state directive principle. These two from 47 along with millet 39B has to be read together. It gives us a power to millet look after the health of the public so that they can live in a very honorous life. Now, so far, coming back to the millet, the fact of the case, there is a curtailment of the some of the ration dealers. Initially, he has started the same. Now, kindly see what is the object of the act. Kindly have a see. Object of act.
Mr. Senguto, when the matter can be again started?
7 except tomorrow, my lord. Tomorrow I have a.
You are not there tomorrow? Day after tomorrow?
No, my lord, I'm not there, my lord. I am not there for my lord. My lord, I've informed my lord.
Not this week?
Not this week, my lord. I'm not there this week, my lord.
Online mode, you can appear?
This matter, my lord, of course, it has to be. I've been waiting for at least a month now, I guess, my lord. Every day I've been there.
I tell you, argument. No, when can be done? I just want
after
to know.
vacation. Can it be done after vacation?
না 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 করব না যখন ওর অসুবিধা বলছে তখন আমি করব
And it's not formally any.
In that event, lordship kindly marked it as a part hurt. Lordship kindly, it will better for us.
Yes,
better for us. Kindly do not pass in interim order. Lordship, fix it up any day after the reopening. I will come and satisfy your lordship because there are 3 points involved.
Whatever maybe. So
in the other matters.
9th.
Sorry, Millet.
9th. First day.
Yes.
There are copy বলছেন Joseph.
Opening, reopening day. থাকবে তো? না আমি থাকবো।
Millet, 9 as we all aware of, it's a very uncertain day. So kindly do not keep it on the 9th. 10th. Then on 10th.
Very. 10th at 10:30 কিছু দিয়েছি? 10 at 12:30.
12:30.
Is it possible for you 12:30 or otherwise I will fix another any time? 12:30?
12:30.
I'm agreeable, my lord. Any day, any time. Any day, any time.
Please take down. Oh, 12:30 আছে?
The only issue is, my lord.
কোথায় কি আছে?
Here such time, my lord.
At 2 p.m.
Very well.
2 p.m.
Very
well. The only issue is, my lord, like in the other two matters, I'm protected till the maintainability is decided, my lord. Lordship has in the morning passed the same order, my lord. That order will continue.
Milord, I am opposing that because once the because I tell you why. I tell you why.
To be taken up every day, I will say.
Because I tell you, Lordship, why. I will at the end of the day, I believe I will successfully demonstrate before your Lordship.
So they let the matter be come in the next week.
Very well.
Mr. Huda, next week you would not be there.
Mr. Huda is now an international lawyer.
No, my lord.
He doesn't believe in the millet,
No,
the rupees. He is believe in the pound and the dollars. He is going to the Turkey. He is going to the otherwise for the international arbitration.
No, whatever. Whether Mr. Huda is coming next week, are you not coming next week?
I will land back in India on 23rd. That's the whole.
Oh, that is not the issue. Then it would become on 10th, 2 p.m.
10th 2 p.m.
The interim order. Like
Milord, I am opposing that. Interim order I am opposing. Because at the end of the day, I will show that he has no locus.
Okay.
Least in 300 matters, Lordship has passed the same.
I understand.
But this matter has not been
This
argued.
matter he raised strong objection.
Yes, correct, Milord.
And you have what is the basis?
Mr. Huda, let it be there. Let it be there. Argument on the point of maintainability raised by the learned counsel, Mr. Suman Sengupta, heard in part. Let the matter appear in the list. June 10 at 2 p.m. June 10 at 2 p.m. as a partner matter. Full stop. Mr. Huda, learned counsel appearing for the petitioner, submits that submits for an interim order. He submits that, like other similar matters, the state authority may be directed to proceed with the selection process, but they must follow the directives of the Honorable Division Bench passed in batch of appeals being MAT 1543 of 2024. It appears to me that the state authority has raised strong objection against the passing of an interim order. I think it would be justified to hear out the point of maintainability first to issue an interim order. Accordingly, the interim order, as prayed for by the petitioner, is refused at this stage.
Minor.
What if I win on maintainability? Then, my lord, and by that time, my lord, license is issued.
License is
issued.
How can it be?
No, the appeal is pending. Everything is going on.
No,
it is not so easy.
In item number 8, license has already been issued. License has already been issued, my lord. The food items have not been allocated. That's the whole problem. Otherwise, I would not have pressed so hard for interim.
202.
Any action by the state should be abided by the
result of
the
Your Lordship, today morning I have mentioned item number 139 to 142 of today's list.
আমি তো বললাম যে টার্কি দিয়ে এটা ফাটেনি বলে
মেনশন ম্যাটার রাখলে কোনটা বলেছেন লাস্টের চারটা তুমি এনকারেজ করবে
আমি অলওয়েজ এনকারেজ করি
any license should be raised করতে বলছি any action taken by the state authority can be abide by the result of the writ petition. Okay, thank you.
Great.
Yeah, 139.